Good morning and welcome to the Public Service Commission of South Carolina. It is Wednesday, July 19th, I think. I'm having trouble with the dates this month for some reason at 10 a.m. and we are here today in docket number 2023-38E and 2023-39E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Urban present in the hearing room. We have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belster. I note for the record that Vice Chair Powers is on sick leave today. I'm going to recognize our staff counsel, Ms. Alicia Clausen, to read the docket.
Thank you, Madam Chair. We are here today for oral arguments in docket number 2023-38E, South Carolina Office of Regulatory Staff's petition for declaratory order, and also in docket number 2023-39E, the petition for declaratory order of Pine Gate Renewables, LLC, and Catalina Solar, LLC petitioners versus Dominion Energy, South Carolina, Inc. respondent. This matter was noticed for today, July the 19th, 2023. Madam Chair, I believe the docket is in order.
Thank you, Ms. Clausen. As y'all are aware from prior commission order, we will have joint oral arguments on both dockets, take a quick break to allow the technical folks to reset, then proceed with testimony in docket 2023-38E. And after we finish that, take a quick break to reset and proceed with docket 2023-39E. And that's how we'll proceed. Let's take appearances from the parties, and then I think we have several preliminary matters that we need to address. Office of Regulatory Staff.
Good morning, Madam Chair and Commissioners. Chad Torrey and Ben Muschin on behalf of ORS.
Thank you, Mr. Torrey. Pine Gate Renewables, LLC, and Catalina Solar.
Good morning, Madam Chair. Charlie Terraney for Pine Gate Renewables and Catalina Solar, and with me is Bland Hallman.
Thank you. Dominion Energy, South Carolina.
Matt Gissenenner with Dominion Energy, South Carolina, and with me today are Ashley Cooper and Alex Brazil with the Baker Donaldson Law Firm.
Thank you. Carolina's Clean Energy Business Association.
Madam Chair, good morning. Taylor Spear for CCBA. I'm joined today by my partner in Raleigh, Ben Snowden, and we're from Fox Rothschild. Thank you for having us.
Thank you. South Carolina Coastal Conservation League.
Good morning, Chair Belser. This is Kate Mixon on behalf of the South Carolina Coastal Conservation League, and with me here today is Emma Clancy.
Thank you. Duke Energy Carolinas and Duke Energy Progress.
Good morning, Madam Chair, Commissioners. On behalf of Duke Energy Carolinas and Duke Energy Progress, I'm Sam Wellborn, and with me this morning is Frank Ellerby of Robinson Gray.
Thank you. South Carolina Public Service Authority.
Steve Pelcher here, and Megan Driggers is with me as well, remotely.
Thank you. And did I miss anyone? That should cover both dockets. Okay, hearing no objection. Okay. I think we have some preliminary matters to begin with, and I think, Mr. Spear, you have a pro hoc vici motion, is that correct?
Thank you, Chair Belser. Yes. Shall I approach the podium?
Wherever you're more comfortable. Okay. Council, you may go to a podium if you can get to one, or you may stay seated. I just need you speaking into the microphones so that you can be heard.
Madam Chair, thank you for indulging CCBA and hearing the pro hoc vice motion that we filed on behalf of out-of-state counsel, Mr. Ben Snowden. There was a bit of a history with this, and we just went ahead and formally filed an application for Mr. Snowden to be admitted in the 39 docket. That application was received, as we understand, by the South Carolina Supreme Court, and the letter has...
We have received the letter. Your motion for pro hoc vici admission in docket 39 is granted. Mr. Snowden was previously admitted in docket 38.
Thank you, Madam.
Okay. We have a couple of other motions that I'm aware of, and let's see. Well, let me look at this. Mr. Torini, you've requested witness protection Is that correct?
Yes, ma'am. Steve Levitas is available, is in a corporate event that he's running today. It's been long-standing. He's available tomorrow. And he is a rebuttal witness in 2023 39E.
We will grant Mr. Levitas protection for today.
Thank you, ma'am.
Thank you. I believe we have a motion to strike testimony filed by Sasiba. No, I'm sorry.
Lead that motion.
Dominion's motion to strike testimony of witness Sowers, I believe. Mr. Cooper.
Morning, Chair Belser, members of the commission. My name is Ashley Cooper, as Mr. Gensendaner introduced, and I do have a preliminary motion on the testimony of Mr. Sowers. And this is raised both for procedural issues as well as substantive. And so the commission set forth a procedure that was very clear. And it said on or before March 6th, petitioners must pre-file with the commission, direct testimony. On or before March 13th, other parties of record, Duke Energy Carolinas, Duke Energy Progress, Dominion, South Carolina Public Service Commission, pre-file with the commission direct testimony. On or before March 20th, petitioners may file rebuttal testimony. On or before March 27th, all parties of record, Duke Energy Carolinas, Duke Energy Progress, Dominion Energy South Carolina Public Service Commission shall provide one copy of testimony exhibits of the witnesses they plan to present. This was filed, there was no direct testimony filed. It was just Sir Rebuttal filed. They issued a petition to intervene on March 21st, which was granted on March 22nd, so outside of these deadlines, and then filed for the first time Sir Rebuttal testimony. So at the very outset, I would say this did not comply with the procedural schedule set forth. More importantly, though, is the substance of this, because it was filed for the first time on Sir Rebuttal. Sir Rebuttal testimony is limited to responding to new facts or issues that were raised in rebuttal. It also can't be things that were in your knowledge that you could have filed in your initial testimony, because you can't use Sir Rebuttal to game it. You can't say, well, wait a minute, I'm going to hold this back and then I'm going to file it so nobody else has a chance to respond. That's why the rules are written the way they are. Now, I want to be very clear. I'm not in any way suggesting that anybody tried to game the system. I'm not. But what I am saying, though, is it's unfair for someone to have an argument they knew at the start, they didn't raise it, and then raise it for the first time on Sir Rebuttal, because the other parties are denied an opportunity to respond. And that's what the South Carolina courts have recognized. And that's what's going on here. That's why Dominion has objected. Furthermore, if you just read the testimony of Mr. Sowers, it purports to respond to witness Cassis, but it doesn't. Let me just read you an excerpt. Mr. Cassis describes, Mr. Sowers notes this in his testimony. In his testimony, Mr. Cassis describes the notice and intervention provisions of the utility facility siting and environmental protection, and mentions many of the parties that are given rights to intervene. My testimony is intended to provide the commission with an overview of extensive environmental and zoning requirements that utility-scale solar facilities undergo in South Carolina, and the extensive agency and public review process undergo even where the Siting Act doesn't apply. So he's not responding. He's acknowledging that Mr. Cassis is sticking to the Siting Act, the requirements of the Siting Act, and the point of his testimony is to go outside the Siting Act and say, well, I'm going to talk about other things that apply even though the Siting Act doesn't. So for multiple grounds, we raised this motion to strike, both because the procedural, because it was things known at the time that could, subjects known at the time that could have been offered originally, and because it doesn't reply to Mr. Cassis's testimony. Thank you very much.
Thank you, Mr. Cooper. Mr. Spear or Mr. Snowden? Mr. Snowden.
Then there's a...
Good morning, Chair Belzer, Commissioners. Ben Snowden here for CCBA. Thank you for the opportunity to be here before you this morning. So as my colleague, Mr. Cooper, noted, Dominion makes two arguments in favor of its motion to strike, one procedural and one substantive. Now, the argument that Mr. Cooper articulated this morning was based on fairness and the ability to respond to other parties. That's a bit different from what was stated in their brief. Excuse me. In Dominion's brief, they stated that surrebuttal testimony would only be appropriate if ORS had filed testimony in this docket, and that such surrebuttal testimony would be limited to responding to issues that were raised in ORS's testimony. That argument is premised on the notion that ORS has the burden of proof here. In fact, this docket is a little bit unusual in that ORS filed a petition for a declaratory order but didn't really take a position on the issue that was raised. So there are no issues on which ORS has the burden of proof. So in this docket, interveners and respondents are effectively all responding to each other. Essentially, Dominion is on one side of the issue and every other party is on the other side of its issue. The clerk's pre-filed testimony letter was very specific that ORS was the only party entitled to file rebuttal testimony on March 20th, that March 20th date. The only opportunity that CCBA or other interveners had to respond to each other's arguments was on the March 27th date for surrebuttal testimony. I am very glad to hear that Mr. Cooper thinks that it is important that the parties be able to respond to each other because that's the only date on which CCBA or any other party could have responded to Mr. Cassis's testimony. I do need to correct a misstatement that perhaps Mr. Cooper was under the impression that CCBA had not filed its petition to intervene until after the date for for direct testimony. That is incorrect. CCBA filed its petition to intervene in February, well before the date for direct testimony. I don't have the exact date, but it was not granted until after the testimony deadlines. That the filing on February, that was on February 21. The filing that Mr. Cooper referenced was simply a letter asking the commission to rule on the petition to intervene. So Dominion's position, as articulated in its brief, is that nobody other than ORS has the right to respond to Mr. Cassis's testimony. We believe that position, in addition to being inconsistent with what Mr. Cooper is saying this morning, would not help this commission develop a complete factual record. It wouldn't be fair, and it would violate the due process rights of CCBA and the other interveners. So on that procedural argument, I think Dominion clearly is in the wrong. Now, substantively, Mr. Cooper claims that Mr. Sowers' testimony is not responsive to Mr. Cassis's testimony. Dominion's entire argument in this case is that the commission has to reinterpret the language of the Siting Act in light of what Dominion claims are the primary purposes of the act, that's environmental review, and that solar projects are evading environmental review and evading public notice if they don't go through Siting Act procedures. Mr. Cassis's testimony, although he doesn't explain the significance of it in his testimony, is clearly intended to support that position and create the impression that the mistaken impression that if a solar facility does not go through the Siting Act, it is not subject to environmental review. So he talks about the environmental review provisions of the Siting Act, who gets notice of an application, what governmental agencies are involved in a Siting Act proceeding, and he talks about what he refers to as the important language about the intervention rights of nonprofits formed to promote conservation, protect the environment, and promote the orderly development of land. I'm sorry, can you hear me okay? Am I sitting? Okay.
We
Thank
can
you.
hear you.
So Mr. Sowers' testimony directly responds to this by describing the review by environmental agencies and local governments that solar facilities will undergo whether or not the Siting Act applies. And he describes how the Siting Act actually undermines that review. So he doesn't so much refute the assertions that are in Mr. Cassis's testimony, but he puts them in context and he explains why Mr. Cassis's testimony is misleading. The rule that Dominion states, I'm sorry, can you all hear me okay? I feel like I'm cutting out over here. Okay, thank you.
No, we can hear you.
All right, thank you. The rule that Dominion states in their motion is that there has to be a nexus between the evidence introduced and the evidence that it seeks to rebut. That is the United States versus Johnson case that Dominion cites on page 7 of their brief. Although Dominion may not like the way that Mr. Sowers responded to Mr. Cassis, there is no denying that there is a nexus between the issues. Now, finally, Dominion does not explain how it is prejudiced by Mr. Sowers' testimony. Mr. Sowers' testimony was filed in March. In the intervening 4 months, Dominion could have taken discovery. It could have sought leave to file a rebuttal. It did not do these things, and it will have the opportunity to cross-examine Mr. Sowers at this hearing. So there is no prejudice to Dominion from the introduction of Mr. Sowers' testimony. And for these reasons, the motion to strike should be denied.
Thank you, Mr. Snowden. Does anybody else want to be heard? Okay. I'm going to deny the motion to strike. There were some procedural errors, I think, here, that the petition to intervene was not timely granted by the commission. It was not granted until after, I think, the direct testimony of ORS was due, and let's see, and also after the all direct testimony was due. I also am sorry that there was some confusion with the pre-file letter, because it indicated that petitioners had to file by a certain date and that all other parties and the Office of Regulatory Staff had to file direct testimony by a week later, which would have given ORS 2 times to file direct testimony, and that was incorrect. I also find that there is a nexus between what's phrased as surrebuttal testimony, but is recognized as being responsive to another intervener, another not petitioner's testimony, and believe that nexus is also important to hear from. And finally, I know that these are petitions for declaratory order, and I think that the commission needs to know as much as possible in making a determination on the legal aspects here of these declaratory orders. So with that, I will deny the Dominion motion to strike. All right. I think we have one other motion, and this was a motion by Pinegate, Catalina, and Sasiba. Is that correct? A motion to strike. That might be a reason for that, Mr. Trini.
Probably a good one.
No, there's a different button on that one, I think. I think that's a different mic. Try it now. No, it's on the base somewhere.
There we go. Okay. In some ways, it's more of the same here. We filed a motion to strike Dominion's responsive testimony because Dominion took the position as in its initial brief that the FERC decision in the Broadview case was inapplicable. And then in its responsive brief for the first time, we find an argument based on the FERC 556 self-certification form for small QFs. So our position was, first of all, it's knowledge that Dominion had, and it's an argument Dominion could have made in its initial brief. It's an argument that is inconsistent with its responsive brief. So it's not an appropriate item for reply. It's not responding to anything we said in our initial brief. In fact, it's just taking a different position. Dominion has made the argument that the motion was untimely filed, and I would direct the commission to the schedule that was issued by the clerk's office, laying out a schedule for responsive briefs to be filed on June 29th, 2023, and reply briefs, if requested by the parties and granted by the commission, to be filed by July 12th. We filed a proposed reply brief with the commission and filed a motion to strike on the basis that Dominion's arguments were inconsistent and inappropriate for response. So the idea with the motion to strike was, look, either this isn't an appropriate argument for the commission to hear, or we have a brief that we believe the commission should consider as a reply brief. Frankly, we're okay with either outcome because we're comfortable with our position on the Form 556. So I'm before you and I say either you should strike this argument or you should consider our reply brief. Thank you.
Mr. Trini, you're relying on the schedule that was set out by the clerk's office that gave a date for reply briefs that was within 10 days of the hearing. Is that correct?
That's right, ma'am. And Dominion is saying, well, there's a rule that says you can't file motions within 10 days of a hearing, but the commission has, in the past, varied that rule. It has the authority to waive rules under its own rules. We interpreted that logically to mean that if we were going to object to something or if we needed to file a reply brief, that whatever we were responding to those briefs from Dominion, it would be due on the 12th of July. So we're 3 days past, I think, the 10-day limit. But frankly, just looking at the schedule, that's what it looked like to us.
Okay, thank you. Dominion, any reply or response?
Thank you, Chair Belzer, members of the commission. I'll be brief in my response. First, I'd note that the chair mentioned in the last motion that this is a motion for declaratory judgment, and so having full testimony, full briefs on the record is helpful in this manner. There's an important distinction that this blurs the line on. This is a legal brief. This is a reply legal brief. This was not testimony. This isn't rebuttal testimony that was filed late that nobody had a chance to see and issues were raised on the first time. This is a legal brief. There's no rule. He doesn't point to a rule that says we couldn't file this. He doesn't point to a rule that says you can't raise a new argument in a reply brief because there is no rule. You absolutely can. Now, the fact of the matter is we didn't. We further responded to their claims and we were consistent with our claims from the start. Let's be very clear what Dominion's position is. Dominion's position is that the Siting Act is clear on its face. It says designed for or capable of greater than 75 megawatts. Dominion's position talked about DC ratings and AC ratings, and DC ratings being the gross capability of the plant, AC being limited by an inverter. We've been clear from that from the start. It's then when you look at the other briefs filed, they said, whoa, the only thing that matters is output to the grid. There's really nothing else recognized but output to the grid. So we said, well, in support of our original argument, there's a FERC 556, and it says, list what your gross production capability is. In this case, it was a Pine Gate plant that's been built. It's under construction. It's in operation. It had a gross output rating of over 100 megawatts. They used an inverter to limit the rating to just under 75. that's perfectly consistent with our argument showing what a plant is designed for and capable of versus employing mechanical means to limit the output to the grid. So this is incredibly consistent. It's appropriate. I really don't know why this motion to strike was made. We're also not being consistent on PURPA. We're perfectly consistent on PURPA. PURPA is a federal law. PURPA is completely different in scope from the State Siting Act. FERC jurisdiction looks at wholesale sales of power. It looks at transmission on the interstate grid. This commission is talking about a siting act that's looking at land use. It's pre-construction. So the holding in a PURPA case is not binding on this commission. We're clear about that. But they brought up this PURPA case, and there are some relevant facts. There's some relevant points in that case, even though the holding's not relevant, that certainly show and illustrate our points that there is a gross capability that these plants have. And I'm going to discuss that more about the gross capability that these plants have. So, for that matter, I just really don't think I need to go on anymore as to the relevance of this.
I don't think you need to get into your oral argument on this motion.
Thank you. Chair, I'll rest then.
Thank you. We're going to deny the motion to strike the reply brief. But based on the notice of the rescheduled hearing that gave parties a date of July 12th to file a reply brief if requested, we will accept the reply brief of Pinegate, Catalina, and Sasiba that was filed. So we'll grant the alternative motion, deny the motion to dismiss desk reply brief. Are there any other preliminary matters? I hope I had them all. Okay. Hearing.
This is Taylor Spear from.
Yes, sir,
CCEVA.
Mr. Spear.
Is the commission aware that a lot of the testimony that's been filed in the two dockets are essentially mirror images of each other with perhaps some additions with respect to 39? And I just wonder if that implicates hearing 38 first and then later hearing 39. There will be some repeat, I believe.
Yes, there will.
Okay.
I'm very well aware of that, but there's some parties in 38 that aren't in 39, so we want to go through 38 and then we'll get to 39.
Understood.
Thank you. Okay, anything further before we begin? And the first part is oral arguments from the parties. Is everybody okay if we proceed in the order that I called or got counsel? That's just how I have you listed, since we're kind of starting with 38. Okay, that's how we'll go. Recognize the Office of Regulatory Staff. Mr. Torrey.
Good morning, Madam Chair and Commissioners. My name is Chad Torrey. I am staff counsel for ORS, joined here today by Mr. Ben Muschin, who is our general counsel. I believe everyone in this room is now aware that ORS initiated docket 2023-38E with the filing of a petition for declaratory order. The ORS petition seeks an order declaring whether the 75 megawatts capacity threshold triggering the certification requirements of the Utility Facility Siting and Environmental Protection Act, which is most likely going to be referred to today as the Siting Act, should be interpreted and applied as 75 megawatts direct current, or DC, or 75 megawatts alternating current, or AC. ORS noted in its petition that it takes no position on the AC/DC issue. The petition presents a pure question of law for the Commission. ORS filed the petition because it was receiving inquiries from various stakeholders seeking guidance on this discrete legal issue. ORS also advised the Commission that it did not believe that testimony from ORS would aid the Commission in its decision-making process with respect to this discrete legal issue. As such, as you've already heard, ORS respectfully declined to pre-file any testimony. The legal issue, Commissioners, has been briefed extensively by the other parties, and I am certain that you are going to hear a robust argument today from counsel for the parties that will further inform the Commission's decision-making process. In summary, ORS views its role in this matter as facilitating resolution of the AC/DC legal issue, which is in fact one of the enumerated statutory duties of the agency. ORS thanks the Commission for the time it's devoted to this matter. Thank you very much.
Thank you, Mr. Torrey. Any questions for Mr. Torrey? Hearing none, thank you. Pine Gate Renewables, Catalina Solar, Mr. Torini.
Thank you, Madam Chair. I'm going to make my way over there. I need to turn my microphone on. Pine Gate Renewables is an Asheville-based solar developer. It has 24 projects in South Carolina that are either operational or under construction. Catalina Solar is the developer of the $100 million project in Saluda County that is the subject of the companion proceeding 2023-39E. And that project is designed and capable, and I don't think there's any argument about its AC output, of contributing 74.97 megawatts AC to the electrical grid. I thought it might just be useful to take a simple look at a solar facility for purposes of today so we can all orient ourselves. I know I've had to orient myself a good bit in terms of solar facilities in the course of this docket. At its basic, a solar facility is made up of photovoltaic modules, the solar panels, if you will, that convert sunlight into DC current. That current is then routed to a device called an inverter. The inverter converts that DC current to AC output. It is the AC output that comes from the inverter, or inverters, as the case may be, that is contributed to the electrical system. So let's take a minute and think about how we got here with this docket. The Commission's historic practice has been to look at AC capacity for siting for years, because that was the only capacity that anybody could look to. The generating plants that you were citing were all AC. With solar facilities, the practice has still been to cite facilities over 75 megawatts AC, which is what you recently did in the S.R. Lambert case. And in all of your proceedings, your IRPs, solar choice dockets, DER dockets, competitive procurement proceedings, you've always dealt, Commissioners, in AC. And as a consequence of this, there are many facilities of this understanding of the Siting Act and the 75 megawatt AC jurisdictional threshold. There are many facilities that are operational that are under the 75 megawatt AC threshold. And that includes a facility owned by Dominion, the Solvoy facility in Ridgeland. It has no siting certificate, and neither do these others. There are other facilities under development that are being developed with this understanding of the Siting Act. Dominion refers to its own solar fleet and its IRPs in AC capacity in its testimony, not in DC. The Commission has approved generator interconnection procedures, interconnection agreements, purchase power agreement forms. They all refer to AC, not DC. Now you're being asked to ignore this practice, depart from this precedent, and adopt a new reading of the Siting Act that is inconsistent with its history and its language. I'd like to take a minute and just talk about Catalina because it is an example of any other facility that would be affected by these proceedings. It's a useful vehicle to look at things. Catalina has inverters that can't produce more than 74.97 megawatts AC. Catalina has an interconnection agreement with Dominion that's limited to 74.97 megawatts AC. It has a purchase power agreement that'll be for 74.97 megawatts AC. It will only be paid for 74.97 megawatts AC. Dominion would know if the output were to exceed that because it has metering equipment that allows it to know that. So it would know if there was if it exceeded 74.97 megawatts AC. And if Catalina were to produce 75 megawatts AC or more, it would be violating the law. It would violate the Siting Act and could be brought in on a rule to show cause before this commission, much like any other facility. So in sum, there is no reason for Catalina or any other facility that is producing output under the jurisdictional threshold of 75 megawatts to violate this act. As you consider the Siting Act, you must follow principles of statutory interpretation that are very clear in South Carolina, and the cardinal rule of statutory interpretation in South Carolina is to ascertain and effectuate the intent of the legislature. That's supreme. It's not unique. It's what you would do under federal law with the Congress as well. So what is the law that we're considering? Under 5833.110, you have to have a certificate of environmental compliance and public convenience and necessity. It's a mouthful. But you got to have one if you're going to build anything that's over 75 megawatts AC. And in the statute, and we'll get to the 75, it defines a major utility facility. Major utility facility. That's what requires the CECPN. The definitional section of the Siting Act, 5833.22, defines major utility facility. And it defines it for our purposes, not for transmission lines, as an electric generating plant and associated facilities designed for or capable of operation at a capacity of more than 75 megawatts. I'd like to dive into this language a little bit. Associated facilities, in the case of a solar plant, necessarily mean the inverters, the transformers, and everything that's associated with the facility. It's the collective of the facility, not the individual components that matter for the Siting Act. And this has been borne out by your previous decisions. So when we talk about a facility that's designed for or capable of operation at a capacity of more than 75 megawatts or more, we have to be talking about AC because these solar facilities can't operate without their inverters. They have no capacity for the grid without their inverters. the statute that tells you how to consider whether to grant a certificate is instructive. And what it tells you is that this is a grid-focused statute, 5833-160. It lays out the factors that you need to consider. And the first factor you need to consider is the need for the facility. And the need for the facility is necessarily dictated by the needs of the customers of the utility, their need for power on the grid. It doesn't matter to them what's being done in isolation. All that matters to a customer is the power that's accessible to them on the grid. You do have to consider the nature of the environmental impact. There's no secret about that. But you also need to consider the impact of the environment and whether it's justified, considering the nature and economics and various alternatives and considerations for the facility. So there's a balancing of the needs of the grid with the environmental considerations. You have to see that the system will serve the interests of system, economy, and reliability. Again, those are grid-focused things. They're not applicant-focused things. You have to know that there's a reasonable assurance that it'll conform with applicable state and local laws, but here the statute is exceptional. It gives you unusual authority in that it allows you to overrule local laws. And why can you overrule local laws or local regulations? You can do it if you find they're unreasonably restrictive, if in view of the available technology, cost, economics, or the needs of the consumers. Again, that is a grid-focused factor in this statute. And finally, like all applications you consider, you have to determine that the public convenience and necessity is served by the facility. And your public convenience and necessity decisions in all areas focus on the public's need, not the applicant's need, not some factor in isolation. So again, this is a grid-centric statute. And if we look at your first decision applying the Siting Act that was passed in 1971, it's instructive and it's representative of every decision you've made afterwards. Order number 16755. It's on DMS, involving an application by Carolina Power and Light. God bless their souls. They're I guess now here in the form of Duke, for a new generating plant that consists of 11 internal combustion turbines generating 58,000 kilowatts each. Here's what you found. You found that the Siting Act applied because you had to consider the sum total of the components of that plant. Each of those generating combustion turbines would not, on their own, have crossed the 75 megawatt threshold. They would have been 58. But 58 times 11 gets you to 638. So you're in. You got to make a decision. You looked at the territory that was served. And Carl, can you pass those orders out, please? I brought copies, and my paralegal, Carl Bell, will pass them out to you as we talk. You looked at the territory that was served, 30,000 square miles with 2.8 million people, 610,000 customers. The other side. Oh, they got them. Okay, and if you can give them to the parties, that'd be great. The net generating capability and generating sources available to Carolina Power and Light. They had 4,748,500 kilowatts. You looked at Carolina Power and Light's historical peak demand. It had grown from 2,270,000 to 4,119 kilowatts. And then you looked at what they were going to need in the future, and it was almost going to be double that. So then you took into account the 10-year forecast of Carolina Power and Light. We didn't have IRPs back then, but you had these long-term forecasts. And the commission noted this forecast was going to be affected, the forecast of resources was going to be negatively affected because there was a delay in the Brunswick 1 and 2 nuclear power plants. They weren't going to come online in time. I know that would come as a shock to us these days, but they were going to be delayed. And the CP&L, therefore, was going to be left without needed summer peak capacity. And this plant was going to provide it. And it would provide it at a cost of $78.75 million, which the commission found to be reasonable. And the commission took into account the environmental impacts, said there was no negative effect on water resources, there was no air pollution concerns. This was a needs facility-based, a system needs-based order, just as all of your orders have been. All of your signing orders begin with the question, is this something that is necessary to serve our customers? And is it the best cost way of doing it, the least cost way of doing it? I'm hung up here. Another principle of statutory interpretation that's relevant to your analysis today is where there's a statute is silent or raises some uncertainty as to legislative intent, you can look beyond the statute, and you should look to the circumstances and conditions that were in existence at the time. It was 1971. John West was governor. Lewis Moss, the longest serving commissioner and public service commissioner in the country, I believe, was chairman of the Public Service Commission. You had privately owned utilities, CP&L, Clinton Mills, Duke Power, still with us. Congratulations. Heath Springs Light and Power, not anymore. Lockhart, they'll be the last man standing, I'm convinced. And SCNG. The Robinson Nuclear Plant had been licensed in 1970. It was the first commercial plant in the Southeast. And in 1969, the General Assembly had passed what it called the Rural Territory Act, and we call it the Territorial Assignment Act. And I think that's instructive to where the General Assembly was and what its concerns were at the time, because the Territorial Assignment Act, for the first time, divvied up the service territories of the various utilities in the state. It gave that assignment to the commission. And the commission's own reports from that time will tell you that the commission was finding that we're at a point in 1971, 1972, that every customer who wants electric service can have it with very few exceptions. So we had a state that for previous years had not been wholly served. It needed to be served in large part by electric cooperatives as well as IOUs. But now we had gotten to a point where there was service and there were concerns about we need to have some order to this. And the commission was tasked with that. It was a grid-focused proceeding. There were no DC sources of generation at the time for the General Assembly to consider in 1971. PURPA wasn't even passed until 1978. Jimmy Carter famously put those solar panels on the White House in 1979, so almost 10 years later. It would have been absurd for the General Assembly to key 75 megawatts to DC power, a non-existing source of generation at the time. It just doesn't make any sense. And a principle of statutory interpretation is that you shouldn't construe statutes to work an absurd result. And if you look at everything else you've done in this area, it would be an absurd result to suddenly have DC generation stick out like a sore thumb in the middle of an AC universe. Your South Carolina generation interconnection procedures that you've approved define nameplate capacity as rated in AC. And you specifically referenced solar inverters. For inverter-based generating facilities, the maximum capacity shall be the sum of inverters related in AC. Your generation procedures say the interconnection request is to be evaluated in AC. Catalina's interconnection agreement with Dominion, again, a form approved by the Commission, total nameplate capacity, AC. The interconnection agreement with Dominion, I think, revealingly says we can have material modifications to this agreement that will require changes to the interconnection study, and we have immaterial modifications. A material modification under the interconnection agreement with Dominion is an increase in AC output. Something that is not an indicia of a material modification is an increase in the DC-AC ratio that does not increase or decrease the maximum output. So the forms we're working on are all key to AC output. Finally, Broadview Solar, which my friend Mr. Cooper talked about at some length in his previous argument, and I'm sure we'll hear more about. Well, let's talk about Broadview Solar. It's analogous. No one's telling you FERC controls your determinations, but it's certainly analogous. FERC had to decide whether its 80 megawatt threshold should be measured in AC or DC for facilities to qualify as QS. And FERC said AC. What we care about is the output on the grid. And that was appealed to the DC Circuit Court of Appeals. And the DC Circuit Court of Appeals said, you know what? FERC's assessment that we're going to look at the sum components of a facility and what they put on the grid was eminently reasonable. The Form 556 that feathers have been ruffled about. It's the form that's filed by a facility to certify, self-certify as a QF. And it is admittedly confusing. It does not say AC or DC when it says gross power. Dominion submitted a form to you that was submitted by Catalina, actually two forms. One iteration of it says, did it in DC, one iteration did it in AC. We believe AC is the appropriate measurement, but the point of the 556 is the form is not determinative. That's what FERC found. They said it's an instructive thing, but it's not the final word, and the form was always entitled to be a flexible tool, and the Court of Appeals affirmed their treatment of that. Finally, there has been a suggestion that the General Assembly was using the 75 megawatt AC threshold, the 75 megawatt threshold, as a proxy for the footprint of a plant. Well, first of all, that argument, even if it generally applies to solar facilities, but not necessarily to other facilities. But more important, when the General Assembly wants to say acres, it says acres. We've cited numerous statutes, and there are more in the code, where the General Assembly wanted to set an acre-based threshold, and it did. If the General Assembly was worried about a land use threshold when it passed a 75 megawatt threshold in 1971, it would have said so. So to conclude, your job is to determine the legislative intent of this statute, and you should look to the time of enactment. In 1971, there were only megawatts around were AC megawatts. The system and the generators were all AC. For 51 years, you've implemented this statute in AC terms. FERC measures capacity in AC. the South Carolina generator interconnection procedures measure solar capacity in AC. Your own approved forms measure capacity in AC. And the General Assembly has referenced AC capacity in statutes such as the Solar Choice Act and the Distributed Energy Resource Acts. It's the only logical conclusion to find that that 75 megawatt threshold should be measured in DC doesn't fit with your regulatory framework and doesn't fit with the intent of the General Assembly and the mission of the Commission, which is ultimately to ensure that the state's customers are served with adequate and reliable electric service. Thank you.
Thank you, Mr. Torini. Commissioners, questions for Mr. Torini? Commissioner Carolee Williams.
Thank you. Thank you, Mr. Torini. This may be appropriate, it may not be, and I'm going to call on this room to tell me or not. In your brief, on page 13, in footnotes 15 and 16, you identify just kind of as extra evidence places in the statute, in the South Carolina statute, where AC is referred to. Are there places in the statute where DC is referred to?
I may stand corrected. I'm not aware of any. And they're certainly not in the context that we're talking about.
Okay. Thank you. No further questions.
Thank you. Commissioners?
Madam Chair.
Commissioner Caston.
Morning, Mr. Torini.
Good morning.
So are you saying that only AC power put into the grid is the determining factor of the Siting Act?
Yes, sir. And I can tell you why if you want me to. I'm saying it is because it's the only power that's put into the grid.
Where does it, in the Siting Act itself, actually, it's a rather long name. Let me find it. I had it just a moment ago. I think it's the Utility Facility Siting and Environmental Protection.
Yes, sir.
Specifically in that act, where does it?
It doesn't. And that's why I think you need to, excuse me.
Where does it mention alternating current, direct current, AC, DC, any of that?
It doesn't. And I'll explain why you should conclude that they meant AC. As I said, there was no DC current available. And if you look at a couple of the cases that we've cited on statutory interpretation, I think they're instructive. You've got Abel versus Bell. Abel versus Bell was a case that involved abandoned school buildings. The state was going through a period of consolidating its school districts at the time, and it had a number of, as a consequence, it had a number of vacant schools. And the vacant schools, the General Assembly said, you know, these vacant schools, these schools mean more to a community than just a school. There were many of these rural communities meet. They have events. And when we close these schools, we're taking away community facilities. And so they passed a law that said the General Assembly, the school districts may contribute the abandoned school facilities to local governments. And there was a school district that said, you know, we've got an abandoned school building, but we're not going to do that. And the Supreme Court said, look, if you look at the totality of the circumstances and the fact, you have these abandoned schools, you look at the way the General Assembly passed this law, they meant you will contribute these buildings to the facilities. So they read it in the context of the circumstances. There was another case called Greenville Baseball, and it was in Greenville County, and it was during World War II, and the legislature passed this law. There was an exception to the blue laws, and it said the Army can have sporting events on Sundays to entertain the troops. And the Army Air Force Division was going to have a baseball game in Greenville on a Sunday, and or rather the Air Corps was going to have a baseball game in Greenville on a Sunday, and the local sheriff said, no, you're not allowed. It only says the Army. And the Supreme Court said, look, if you look at the context in which the legislature passed this bill, obviously they meant to allow military troops during time of war to be entertained to have access to entertainment on Sunday. So my point is you look to what was around them in 1971, and if anybody in 1971 said 75 megawatts, they were obviously talking about AC because there was no possibility of DC.
Well, so let me ask this. Does the Utility Facility Siting and Environmental Protection Act, I threw the act on there, it's not in the statute, the Siting Act.
Mm-hmm.
In your brief,
yes,
sir. Does it address, is the Siting Act relative to the environment on the ground, or is it just the Siting Act, just interested in electrons that go through an interconnection?
Now, there's clearly an environmental component to the Siting Act, and you have to evaluate and take into consideration the impact on the environment. If somebody were going to site a facility that would harm the environment, you should take that into account. So there's an environmental component, of course.
Where does it talk about interconnection or grid?
Well,
in the Siting Act.
If we go, I can figure out how to bring the Siting Act back up. I'll speak to that. I think it does, Commissioner, where the Siting Act talks about capable of operation at capacity. Now, it doesn't say interconnection. It doesn't say the grid. But my point is, when you look at 583320 and you look at 5833-160, which are the factors you have to take into account, they're all grid-focused factors. You don't get to the consumers, you don't get to the needs of the state without the grid. So we're looking to the electrical system necessarily in the Siting Act. When you talk about design for or capable of operation, operation obviously means putting power on the system. I mean, otherwise, I could, run a car in a bean field someplace, and what would it matter? Why would we be in Title 58?
Okay. Hypothetical then.
Mm-hmm.
If this were any other generation, along the definition you've been kind of giving me, whether it's oil, gas, coal, nuclear, generation facilities designed for, capable of, whatever, 77 megawatts, 98.89, 160, whatever it is.
Sure.
And it throttles or limits what goes into the grid to 74.97 megawatts. would or should those facilities be exempt from the Siting Act?
There are a couple of things in your question, and the answer is if they don't contribute more than the jurisdictional amount, they should not be covered by the Siting Act. So if they're not putting more than 75 AC onto the grid, no, they're not covered, whether they're coal, gas, power. And you know, look, you don't anymore, but as we saw in the Darlington case, you did have the capability, at least we don't see it much anymore, to have conventional generation at under 75 megawatts AC back in 1971. So that's relevant. I also just need to point out that the inverter is not like a governor on a driver's ed car that says you can only go this fast. The inverter is actually producing the AC output. It's taking that DC and changing it to AC. Now, the inverter has a rating, and that rating, you know, there's been some talk about can it be manipulated, can it be changed. I think testimony can show that it's not like you can go out there and turn a knob on the inverter and jack it up to 80 in the middle of the night. It's something that's pretty difficult, if possible, to do, and would also violate the law, after all. And you have to presume that we're going to observe the law. But yes, to answer your question, if I've got a coal plant and DHEC lets me run it, and it's 74 megawatts AC, it's not subject to your siting.
So what I'm hearing you say as far as the Siting Act is concerned, in your opinion, is that regardless of the size of the generation facility, Dominion comes in and says, we want to construct a 500 megawatt coal plant, but we're not going to put more than 74.97 in the grid. You're telling me that the Siting Act would have no interest in that other than only 74.97 is going in the grid?
I can't imagine why Dominion would want to do that, but I am telling you, no. As the Siting Act is written, 75 megawatts is your trigger. Now, DHEC may have something to say about it. The local government may have something to say about it. If you're under 75 megawatts, it's not like you're in the Wild West. You've still got to go to the county, just like Saluda did, had to approve Catalina. You've got local government zoning control. You've got environmental controls. You've got a lot of other things, and you've got agencies that are specifically tasked with governing, with applying environmental regulations, and they're still in effect. As a matter of fact, you arguably have less oversight, with all due respect to y'all, over a Siting Act covered plant than you do one that's not. Because if it's over 75 megawatts and Saluda County says we've got a regulation that says we don't want it, and you think it's necessary, you can override Saluda County. So again, that's where the premise that this is an environmental statute first, and instead of a grid-centered statute, is upside down. It's a grid-centered statute with environmental protections built in, Commissioner Castor.
75 megawatts AC.
Yes, sir.
And you're saying the Siting Act is totally grid-centered?
Well, I'm telling you that the triggering mechanism of it and the intent of this Siting Act, I didn't say totally, you've got to take into account environmental considerations, but I am telling you that it is triggered by 75 megawatts AC. That coal plant with 900 megawatts that is, as you said, throttled down. I'm not sure how you do that, but if it is, those are all AC megawatts. They're all AC. Let's keep that in mind.
If the General Assembly, as I think you had mentioned earlier, when you had addressed perhaps the intent, I think looking at the history when I was reviewing the Siting Act multiple times.
Yes, sir.
They amended the law in 1993, Act 181, 2006 Act 318, 2019 Act 62, 2021 Act 90.
Right.
And I imagine there was opportunity to do whatever they wanted to do to clarify AC, DC, mention it or whatever.
Yep.
But they chose to kind of just leave it like it is, other than just the amendments that they put in.
Right.
So
I'm sorry.
So go ahead and respond what you were going to respond.
Sure. There was no need to, because this argument first appeared in front of you in the Orangeburg Solar case, which was what, 2 years ago? So as far the status quo has been AC. The status quo has been AC through conventional generation, and then when solar came online, it's been AC, as evidenced by everything you've done in terms of interconnection procedures, et cetera. Then suddenly, Orangeburg Solar comes up. They're asking for a like-kind facility designation on a timeline, and Dominion shows up and starts making this 75 megawatt argument, which incidentally was pending at FERC at the time, I think. So the General Assembly didn't have any reason to do that. But I would say, if you look at the amendment to the Siting Act, I think it was the last one, they went into they gave you further criteria on efficiency considerations, on necessity determinations. Again, they're looking to the grid. It's not exclusively grid-focused, Commissioner, but environmental concerns have to be taken place, but it's always been AC. So the General Assembly, when it's passing these laws, really had no reason to think, hey, we need to change this.
I have a question.
Thank you, Commissioner. Any further questions? Commissioner Justin Williams?
Thank you, Madam Chair. Good morning, sir.
Good morning.
Just have a few questions for you. I appreciate the history that you gave. Just thinking about that history, I wanted to know whether or not you knew if inverters existed in 1971.
I believe the testimony in this case will tell you that they weren't in commercial operation. I have no idea if an inverter as a theoretical gadget existed. Gadget's not a good term. My client's going to get mad at me for calling it a gadget. But as a device, I don't know. But there certainly weren't any that were looking to be part of a facility that was going to be on the grid that I'm aware of.
Okay, understood.
Thank you, Commissioner.
Okay, understood. Thank you for that. So if I understand your argument, the General Assembly, I guess somewhere about 1971, whenever the Siting Act was passed, they were only concerned with AC generation because that's the only generation that existed at the time.
Yes, sir.
Am I understanding that correctly?
Yes, sir.
Okay. So taking that thought a little bit further, would it be fair for the commission to find or to infer that if AC generation was what was only considered at the time, then it's highly unlikely that the General Assembly at the time thought about inverters and their use to take DC generation and make it AC generation or convert it to AC generation to be put onto the grid. Is that a fair
I would agree with
inference?
Yeah.
Okay. All right. Thank you for that. Could you explain to me a little bit more how the inverters work? You briefly went into that it not only converts the DC generation to AC generation, but it does several other things. Could you, to the best of your ability, walk through that for us, please, sir?
Commissioner, we have witnesses that are going to be far better at it than I am. But I'll tell you that generally what they do is a direct current is coming in, just picture a line, and AC current will come out and picture a cycle. You know, it's intermittent. So we go from direct to intermittent. And what the converter does, in a way that is way beyond my liberal arts education, is it will take that current and cause it to be an output of AC. And that's the best I can do for you. We have a witness who's very capable of explaining that.
Understood. Thank you for that. So the nameplate capacity in this particular case for the inverter is somewhere right below 75 megawatts. Is that
Yes, sir.
right? Is that something that has to be specifically set or limited or programmed into the converter? Inverter, excuse me.
Yeah, when you order the inverter, when the inverter is made offsite by a manufacturer, I've forgotten who does ours, but it comes to you as made to produce 74.97 megawatts. So obviously you tell the folks, we want to stay below the jurisdictional limit, no secret there. And so we want something that's not going to have an output of more than 75. They send it to you. It comes, if you want to say programmed, but it's designed for an output of 74.97.
Okay. So why do you need more than 75 megawatts DC?
Okay, good. That's a great question. You always hear in your solar proceedings and in your IRP proceedings, for instance, that the problem with solar is it's intermittent. The sun shines sometimes, it doesn't shine at other times. And so you're never going to get, or very rarely, the full 74.97. So by getting additional panels, what you can do is smooth out that generation and better approach your 74.97 megawatt limit. So there are going to be some system losses anyway, I think, in the inverter process. But so that's why these panels, and you're going to hear in testimony, are usually sized to be like 1.2 times the ultimate AC output capacity. It's just to get the most out of them within the jurisdictional limit.
Okay. And you say that your liberal arts education limits you when it comes to inverters, but I would argue you're probably more educated on the matter than we are. I could be mistaken, but I thought that the inverter in and of itself when it converts the DC generation to AC generation, that that's what's going to limit how much goes into onto the grid.
You're absolutely right.
Okay. So are you saying that because of the inefficiency of the solar panels, in order to maximize output, more panels, if you will, are constructed?
Right. I'm sorry. Go ahead.
No, I'm finished.
Yeah, they're going to deteriorate over time a little bit. So in order to maximize the efficiency of that system, you just gross it up by 1.2 maybe.
Okay. Do you have any idea how much more land that takes up? For example, if I think we would not be here today if the system in question was below 75 megawatts DC.
Fair enough.
Is that a fair inference?
Yeah, sure.
Okay. So I'm trying to understand what is the difference between a 75 megawatt DC solar array, and in terms of space, size, space, land that's disturbed compared to one that's over 100 megawatts DC.
And I think what you're going to hear is there's no hard and fast rule. And I'm not trying to be evasive here. I mean, generally speaking, if all things were equal and you said, I'm going to have 95 megawatts DC and 100 megawatts DC, and the topography was the same and everything, and the panels were the same, yeah, the 100 one is going to take up more space. But that's where it ends, right? Because there are a lot of things that go into the size of the plant. It has to do with the type of the panels. It has to do with with what they call the solarity, the ability of the panel, the solar exposure of the panels, for lack of a better word. And this technology changes. I understand, and my friends at Dominion can correct me if I'm wrong, that their Ridgeland facility is on 900 acres. We're not even close to that. And so the point is, over time, it changes. So I can't give you a hard and fast rule. I can tell you generally, Commissioner, you're right, but there's no equivalency of one panel equals half an acre or something like that. It just doesn't work that way.
And so, thank you for that answer. And so, going back to, I guess, a point Commissioner Caston was trying to make, regarding the size of a facility. I think he used a coal facility.
Yeah.
I think he used a pretty big number, like 500 megawatts. Your position is that the size of the facility, no matter how large, even though we may be reaching or approaching absurdity, but from a hypothetical perspective, the size of the system doesn't matter as long as what's going onto the grid is below 75 megawatts.
Well, what I'm saying is that's the law, that's the hand the General Assembly dealt us, right? I mean, the Siting Act, as far as the Siting Act is concerned, no, it doesn't matter. And I would point out, I mean, think of the technology you have now. You could put a modular nuclear reactor on 10 acres of land. It has a footprint, as I understand. So there's not a correlation here. That's why I say it was a grid-centric statute. Because if you look at all of the things they're asking you to consider, along with the environmental impact, they're asking you to determine whether this thing is needed.
I think that's all the questions I have for you, sir. Thank you. Thank you, Madam Chair.
Thank you.
Thank you, Commissioner. Anything further from Mr. Trainee? Mr. Trainee, thank you. Appreciate
Thank
your
you, ma'am.
argument and your patience with us. We've been going about an hour and a half. Do you mind if we take a 10-minute break, or a little more than 10 minutes? We'll come back at 11:40. And Dominion will be up. Good morning and welcome back to the Public Service Commission of South Carolina. We are continuing with oral arguments in docket numbers 2023-38E and 2023-39E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin, and present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. We will now go to Dominion for oral argument. Mr. Cooper.
Thank you, Chair Belser, members of the commission. Before I begin the prepared text for my oral arguments, I wanted to respond to just two things that were subjects of commission questions, just to clarify. In terms of solar technologies, there's certainly evidence that as far back as the 1950s, there were solar technologies. There's USSR 1971. That's really immaterial. The point of this is, it's not like PURPA came into to law and then solar plants automatically happened. PURPA was a response to what was going on at the time. I wanted to clarify that. Even with those clarifications, it's really immaterial to our decision today for reasons I'll explain. Further, there was a question about, is there any reference to DC rating in the SCGIP? And there is. Not a lot, but there is. And we'll talk about that more in my remarks. So to begin, I thank you for this opportunity. I want to be clear about why we're here. I respect, I want to go on the records. I know these lawyers personally, individually. Very talented, good group of people that I personally like working with and consider it a privilege. But I want you to listen carefully to what everybody says. This isn't a Dominion initiative. This isn't something Dominion's trying to do or a plan they've hatched. And that's clear even from Pine Gate's petition. Just read their petition, right? They say that this commission came and issued an order in Orangeburg Solar and said, if we were going to look at the Siting Act, it would be helpful to know the DC rating. So Dominion's a regulated utility. It has the question put to it. And what does it do? It now has this information. It says, well, let's go to the commission and find out. This is your obligation. It's not our obligation. Okay, so this is not something Dominion's trying to do. Now, let's be clear, too. If you say the Siting Act applies to AC, and Dominion can build a gas plant and build a 200-megawatt gas plant and limit it to 74.98, well, that applies to Dominion. If you say, no, this is about gross rating, it applies to Dominion. So whatever you do today, it applies to everybody in this room equally. So this is not some, Dominion. It's also a suggestion that Dominion was turning precedent in the state on its head or creating new precedent or something that kind of had a negative connotation that this was like some sort of conspiracy to deny justice. It's not. I mean, again, go back to Pine Gate's petition and look at the ORS's petition. What do they say? This is not, there's not well-settled law. They're not asking you to change your holdings. What do they say? They say this is a matter of first impression. The commission's never gone on record. That's what we're doing today. We're just clarifying something. So that's it. So what do we have to do to get this clarification? I think one thing is we have to think about what the purpose of the Siting Act is. And I go back to my earlier statement of it's important to think about this in the context of the jurisdiction of this commission, the focus and concern of a state legislature, the jurisdiction of the Federal Energy Regulatory Commission, because they're very different. So when you start to point to the Federal Energy Regulatory Commission and say, well, look at what they did, it's a bit like me going into a property tax appeal and saying, well, let me tell you about how the estate tax works, right? Well, they're both taxes, but they're different. They have different goals. They were meant to achieve different results, right? So the FERC is concerned with the selling of power in interstate commerce and the transmission of power in interstate commerce. That's what it's concerned with. So it's concerned about the bulk electric system. It's concerned about what happens on the grid. Now, has the FERC tried to expand their jurisdiction, get into some state jurisdiction like siting? It has, but it hasn't been successful because the jurisdiction of this commission in this state is about generation. It's about siting generation. It's about the health and welfare of the citizens of this state. So with that context, let's look at the Siting Act and how it relates to what our job is here. Now, you'll hear from probably every one of us that talks about the rules of statutory construction. We all agree about it. We just believe it comes to a different place. The cardinal rule of statutory construction is to ascertain and effectuate the intent of the legislature. The best evidence of the legislative intent is the plain language of the statute. All rules of statutory construction are subservient to the one that the legislative intent must be prevailed if it can reasonably be discovered in the language used. And the language must be construed in light of the intended purpose of the statute. So rather than talking a lot about other examples, other laws, I want to spend a lot of time talking about the Siting Act and see where that goes and where that takes us. Let's see if you can. I have to admit that I bet there was a bet between Ms. Brazil and Mr. Gissendaner that either one or the two of them didn't think I could put this up there and then zoom in. So I may be collecting dinner tonight. Let's look at this act, though, and what it says. It says that electric generating, what is a major utility facility? It's an electric generating plant and associated facilities. It doesn't say components, it says facilities. Designed for or capable of operation at a capacity of more than 75 megawatts. This is not vague. This is not unclear. The legislature defined for you how to determine whether it's more than 75 megawatts. It said, look to see if it's designed for or capable of. That's your interpretation of the 75 megawatts, designed for or capable of. It does not say, and you cannot respectfully, under the rules that I just read you of statutory construction, you may not read into this that the law says the following: designed for or capable of operation at a capacity of more than 74 megawatts at the grid level. That's reading words into the statute that are not there. There is no reference to AC or DC. What's the most logical result? It means whatever tells you what the plant is designed for or capable of is what's important. We're really kind of getting ourselves wrapped around the axle. Is it AC? Is it DC? Which one? Is it only one? Can you only choose one? And then there was some suggestion that Dominion really wanted to choose DC because they wanted this to apply to solar, but not coal plants. No, that's not true. We're saying this act is South Carolina legislature has been clear. And they've told you right here how to interpret it. Is it designed for, is it capable of? Whether it's AC, whether it's DC, whether there's some other measure that comes to light in the next 10 years where we've seen technology change. That's how you apply it. All right, so let's also think about the context of this. This act is a pre-construction act. So if it's pre-construction, why would it be concerned with how you're going to operate at the grid level? Right? It's saying, what are your blueprints? How is this thing going to be designed? It says, look at the term. It says, commence to construct means any clearing of land, excavation, or other action that would adversely affect the natural environment of the site or route of a major utility facility. No person shall commence to construct a major utility facility. What does that mean? Commence to construct. No person shall commence to construct, clear, or excavate a major utility facility. So again, this is about the gross capability of the plant, not about its effect on the grid and what the grid's going to see. This is a pre-construction requirement. And we've talked extensively about this in our briefs. But it's very careful to say who's included in this pre-construction review for Siting Act. And this is what the legislature said. They said the Office of Regulatory Staff is automatically a party. Department of Health and Environmental Control, Department of Natural Resources, Department of Parks, Recreation, and Tourism. Now, do you think that the Department of Parks, Recreation, and Tourism, do you think their focus is on land use, compatibility with the environment, compatibility on historic sites, or do you think they're saying, well, let's look and see what the impact will be on the grid? Let's see what this does once it's actually floating on the grid. It says each municipality and government agency entitled to receive service of a copy of the application. And then I also want to read to you Section D. Any person residing in a municipality entitled to receive service of a copy. Any domestic nonprofit organization formed in whole or in part to promote conservation or natural beauty. That's one. So if you are a domestic nonprofit to promote conservation or natural beauty, you should have standing. To protect the environment. A lot of people are saying, well, where's Dominion going? They're saying this is about the environment. Well, we looked at D, and it said protect the environment. Personal health. It's another issue. If you're a group that's concerned with public health, well, you have standing, according to the General Assembly. Other biological values. To preserve historical sites. Now, are the historical sites going to be impacted by a 200 megawatt gas plant that's limited to 74.98? Or do you need to look at the gross capability? Do you need to look at the gross capability of a solar plant versus its limited inverter rating to determine the impact on historical sites? These things tell you more about the intent of the legislature in developing the Siting Act. This is part of the Siting Act. You don't have to go outside of the Siting Act. So why is Dominion the only one talking about this instead of a plant that was developed in 1971 or a FERC case that deals with impact to the grid? I mean, this tells you the impact in the intent of the legislature, and it's right in the act itself. The other thing that the Siting Act does not include, the Siting Act nowhere states, well, these are our requirements. But if you can show that you satisfy these requirements by some other means, then don't worry about the Siting Act. So if the Siting Act is saying, look, we want to look at land use and the impact on historical sites, you don't say, well, that's great, but we complied with a different law, so Commission, you don't have jurisdiction over this. That's not what the Siting Act does. It doesn't give you an alternative method of achieving compliance or demonstrating compliance. Now, I mentioned this to you. There are actually several places where we agree, we just come out to different conclusions. So these are from the brief of Pine Gate Renewables in Catalina. This commission has historically looked at the facility's capacity to generate an AC, which is form that flows across the grid. It says photovoltaic panels at solar PV facilities, by contrast, convert photons into DC energy. Instead of a generator, DC energy is sent to an inverter, converts it to alternating current, can be put on the grid. It says the output capacity of inverters determines the nameplate capacity facility. I don't think that's correct. You look at their footnote, That's footnote 4 to the U.S. Energy Information Administration, March. And I don't think that's exactly what that was saying, but I'll tell you what that report was doing. It says the title of that report was Solar Plants Typically Install More Panel Capacity Relative to Their Inverter Capacity. So what's clear is they pointed to a study that talks about how the DC capacity typically always exceeds the inverter capability. But it does not say, and I think they acknowledge they're uncertain here, but it does not say the output determines the nameplate. And I'll show you why that's just not the case. The other thing is to look at their briefs and their petitions and look at the testimony of witness Hopkins, because it's not Dominion. Pine Gate's acknowledging, and I give them credit, they're very upfront in their briefs, and they say typically a solar facility, a solar generator, is designed and it has a DC capacity which exceeds its AC capability. But it limits the power it puts on the grid. And they spend a fair amount of time talking about how you can trust in these limits. And it talks about the inverter. I know Mr. Trini didn't talk about the limits so much this time, but in their briefs and in their filings and their testimony, they do. And they put a lot of stock in saying you, Commission, can rely on the fact that these inverter settings, when we set them, whatever value we choose 74.98, that might be close, but nothing else goes on the grid but that. It is accurate in the amount it limits the power. Well, if it limits the power, by definition, it must have the capability to do more. So let's look at this Broadview case that was cited. It was cited extensively by Pine Gate. And again, I don't think that the holding in Broadview applies to you at all. I don't think it's instructive at all because it looks at the FERC's purpose. So let me show you what they said. It said, determining qualifying facility status by the facility's net output, brings various provisions of PURPA into harmony. One of the main benefits of being a qualifying facility is mandatory purchasing requirements. So they said, well, what is most in keeping to determine a mandatory purchase obligation? Because that's the impact of PURPA. That's what PURPA is about. And they said, well, it's not about the gross amount that this plant can produce. It's about the limit that this plant can put on the grid and force the utility to purchase. That also happens to square with the jurisdiction of the FERC. So in determining this statute, what did the courts do? They said, let's look at the purpose of the legislation, and we'll decide this. And that's what we're saying to do with the Siting Act. I also want to take a second to show you what they said in this in this case about Broadview facility. Let me read this to you. It says the facility will include a coupled array of solar PV panels with a gross capacity of 164 megawatts of direct current and electricity, and battery storage system with a capacity to discharge 50 megawatts of DC electricity for up to 4 hours. Read this next part. When the solar array produces more DC electricity than the inverters can convert to AC electricity, the excess DC electricity will be stored in the battery storage system and will not be delivered to the point of the interconnection with Northwestern's system until a later time. That's an important fact. Have you heard that about Broadview? There was a battery storage. So what were they able to do with this 160 megawatts of DC? It wasn't that they couldn't do anything with this DC. See, listen to the words carefully. The words carefully, because there's going to matter, because others are going to go too. They're going to come up with a very strong statement that says, DC doesn't matter because there's nothing we can do with DC power on the grid. See, there's always going to be that on the grid. But what was this plant? This is not a hypothetical. What did this plant actually do with that DC capability? With its gross capability, it limited its output to the grid. That's very true. But what did it also do? During sunny days, where it could produce more and go towards the design for capability of the plant, it took extra power at the same time and put power to that solar storage facility, which was DC. So it could go DC to DC. It didn't need an inverter. So does it have a use for this extra DC? Can it do something with DC beyond what it puts to the grid? Absolutely. And that's not Dominion's position. That's the Broadview case that they put into this docket and they sent to you all. This is a finding. The holding in PURPA is not instructive because PURPA is about mandatory purchases. It's not about pre-construction. So I want to be very clear. So when I bring that up, I just wanted to show you this court talks about there is a usefulness to DC power and this DC design for capability. It's also instructive to see what the court did. They say, well, interpreting this, let's think about what the overall intent or the purpose. They didn't say, what's the industry standard? They didn't go and say, well, what does NERC do? They said, what is the language of this statute designed to promote? And what gives effect to that? So here we have a pre-construction act that looks at land use, looks at impact to historic relics, it looks at health and safety, other biological matters. You've also heard references to the South Carolina generator interconnection procedure. Again, I think that's a great discussion. I think we both ought to talk about it because I think that, like PURPA, it doesn't settle this answer. But you have to consider what was the General Assembly trying to do with an interconnection procedure. An interconnection procedure, they weren't worried about public health. They weren't worried about impacts to relics. They were worried about the ability to interconnect to the grid. They were worried about the ability to put power onto the grid. And what did they do there? They didn't just say, according to Pine Gate's legal theory, the legislature shouldn't have had to say anything because it was obvious it was AC. But no, what did they do? They clarified. And they said, for looking at an interconnection, look at your net output in AC. They felt the need to clarify. So just as Pine Gate mentioned, were they making amendments to the Siting Act about the same time? Yes. The Energy Freedom Act made certain changes to the Siting Act. They didn't feel the need to go back because they said design for and capable of is clear. It's the gross output. But in the Interconnection Procedure Act, this is roughly equivalent time, they said, hey, we better clarify because if we don't, you may not know that it's in this context for an interconnection, which does. They're exactly right. An interconnection procedure, we agree, something we all agree on. It concerns with what you put onto the grid. And that, the legislature was very specific and said, give us the net output in AC. At the end of the day, this is not something like PURPA. PURPA, you're either over 80 megawatts or you're under. And if you're over 80 megawatts, you don't get the benefit of mandatory purchase. Applying the Siting Act as the legislature intended, it's not the death knell for anything. It doesn't prohibit you from going forward. It just says you must comply with it. It just says you must recognize the act, its requirements, and come before this commission. So you're not making a decision today that says, well, if we decide one way or the other, there'll be no more solar, there will be. You're not making a decision today that says, well, there'll be no more gas, or there will be. There'll be no more landfill gas renewable plants. There'll be no bio-waste renewable plants, right? Those are in AC. You're treating everybody equally. You're treating everybody equally when you say, we're going to apply the design for capability of the plant. That's what ensures you treat everybody equally. And then you say, okay, well, is it AC? Is it DC? What is the gross output? What's the design for capability of this? That's how you ensure every class of generator is treated fairly, and you apply the act. I thank you for the time, and I'll stop and see if you have any questions for me.
Commissioners, questions? Commissioner Caston?
Thank you. And it's good afternoon now, Mr. Cooper.
Good afternoon, Commissioner.
Well, I think I'm hearing you argue for Dominion, and I want to make sure I'm right.
That's correct.
In this case, relative to, I guess, the FERC and the FERC Broadview rehearing an order, and then the DC court, which, by the way, I read those, including the dissenting opinions. Dominion's position is that relative to FERC, is it relates to the certification of a QF, in this case, the Broadview, whether it was or wasn't. First time around, they said it wasn't. Second time around, they said it was.
That's right.
And the reason that's important is if it's a QF, there's a mandatory requirement for the utility to purchase the electricity. Is that correct in what you're saying?
Yes, Commissioner.
Does the Siting Act, anywhere in the Siting Act, address in any way QFs, mandatory purchases, or anything like that?
No, Commissioner, it does not.
I think the rest of my questions really probably be more technically oriented. Not that I doubt you don't have the capability to answer that, but.
Commissioner, I'm not going to disagree with you over that one, so it's probably a fair assumption. I see Mr. Cassis, he was getting ready to come here and pull me off if you ask me something technical.
And I guess relative to the act itself, it's Dominion's opinion that the Siting Act is focused primarily on pre-construction, on the ground stuff, environmental impact, is it disturbing historic sites, whatever. Is that correct?
I think that is part of the overall focus of the act, and that is an important part of the act. Are there other things in terms of need or efficiency? Yes, but we're saying these parts of it have been overlooked by others, and we're saying you cannot, when interpreting design for or capable of 75 megawatts, we think that's very clear. We don't think that needs further clarification because it would mean whatever is that gross capability, and that opinion is further supported when you look at the act's express provision to allow people to apply and participate who have a concern for environmental impact, land use, historic relics, other biological matters, public health in general. We say that's all. You've got to look at that site and that footprint of the site and the design capabilities of that plan. Because let me make one other point clear, and this is getting close to a technical point, but I think I can make this. If you look at it from FERC's perspective, and they're concerned about the grid, they don't see a difference between a solar facility that's 160 megawatts with a 50 megawatt battery. To them, they don't see a difference, because what they care about is at any one time, at any moment in time, I believe that was Pine Gate's language, it will never exceed 80 megawatts. So they don't see anything beyond that. You could have a solar facility at 160 megawatts. You could have a battery. You could have another battery and another battery if it was economical to do that, right? Because they know all they care about is seeing is the 80 that's inserted or injected to the grid. The Siting Act, I submit, that says before you excavate, before you clear any land, you need to look at land use. I think you absolutely see a difference as to whether there's a 160 megawatt plant and a battery. Absolutely.
I don't remember in that FERC order, in that particular docket, where it mentioned anything about the acreage, 160 megawatt array. Did it mention anything about acreage?
No, Commissioner.
And the other things I think you were talking about that's in the Siting Act, which I guess I'm not going to read them, but if it qualifies, if it's 75 megawatts or greater, then there are other things too, like is it needed? Right. Is it required? That's some of the other things you were talking about.
That's correct, Commissioner.
No more questions. Thank you.
Thank you.
Thank you, Commissioner. Commissioners, questions for Mr. Cooper? Commissioner Justin Williams?
Thank you, Madam Chair. Council, good, is it still morning? No, it's afternoon. Good afternoon to you.
Good afternoon.
Just a couple of questions. And before I get started, I just want to give you the appropriate frame of reference of where I'm coming from. Have you ever heard of the saying, you have what's said, what's written, and then what's actually practiced?
Yes, Commissioner. Or words to that effect.
Right. Could you succinctly tell us what's really going on here? Because we've heard what you've said. We know what's written, and we know what we've practiced as a commission. But what is really at stake here for the commission for this decision?
And Commissioner, if I can answer your question by maybe providing some context for how we got here, so Dominion's perspective, and then what's at stake for the commission. I'll try to answer both of those if I could, because you said also what's the state of things. I would say prior to the Savion case and prior to the commission saying we should know more about the DC rating, I think it's fair to say that the Siting Act was really something that was just the obligation of the person developing the generating facility. So whatever they did, I mean, it wasn't Dominion's obligation unless it was a Dominion plant and it was developing the plant to comply with the Siting Act. But I think that, whatever Pine Gate may have chosen to do, and if they were willing to say, hey, we've complied with all laws, which they're required to do in their PPA, that was just kind of accepted. But then Dominion got extra clarification. The commission said, hey, wait a minute, we would like to know. The DC rating would have been helpful to us. That didn't shift an obligation to Dominion. But Dominion's a highly regulated company that appears before this commission regularly. So Dominion at that point said, okay, this is still your obligation. Pine Gate's not ours. But we now know the commission saying it would have been helpful to know this. You need to get clarification. And we'll tell you what, we will suspend the requirements in our agreements so that you don't have to worry about your plant being in default. Okay? And that was a request from Pine Gate, to be clear. They made that request, and Dominion said, okay. And they said, but Dominion said, you should get clarification from the commission because we've seen enough now that, we kind of now have some obligation to the commission. They said they want to see the DC rating. We'd feel better before we buy your power that you shift any of this to us, essentially, right? So go get clarification. They may say you don't have to comply with the Siting Act. They may say you do, but we now all have enough. So that was kind of the state of things and how it came here and why it came to you. And I think Dominion was in a unique position where this was put to them first, right, than other utilities. And so it felt it had this obligation first, just the timing of it. And then I think what's at stake for the commission is, it's your jurisdiction. The legislature said you have jurisdiction, and we're putting siting for 75 megawatts to you. So what's at play is you have to decide whether, do you think that your jurisdiction extends to the gross production capability of a plant, or do you think that no, it applies as it's limited by an inverter and converted to AC and what goes onto the grid? So those are the two things as to kind of how we got here and what's at play, respectfully.
All right. Thank you for that. I want to transition to fairness. You use an example, and I don't know. I can't really say whether or not the example was based in reality or not. But you use an example of a 200 megawatt gas facility. If Dominion were to seek to place a 200 megawatt gas facility online, but limit what goes into the grid to below 75 megawatts, that under Pine Gate's interpretation of the statute, that Dominion could be or should be allowed to do the same. Is that, and this could be somewhat speculation, but we don't know what we don't know today. We don't know how technology is going to change, but if we do interpret the statute the way that Pine Gate wants us to interpret the statute, is it your opinion that it does leave room in the future with some, world-breaking new technology to come in and build maybe a facility that takes up a large amount of space, but only limits what's put into the grid to 75 megawatts? Is that a real threat?
Well, Commissioner, I think there are two parts to that question, which is it a real possibility, and is that something that's a likely scenario? So I think Pine Gate acknowledged in their arguments, they said, yes, it's if you say that the standard is what you can put at the grid, and that's the measure, then that applies whether it's solar, whether it's gas, whether it's coal. So, any plant that is built to 160 megawatts, 200 megawatts or more, if the standard is, well, we're only going to look to what you put at the grid, then I think that it would be setting into motion a holding that says, okay, we're just going to count what's capable of being put at the grid. And if you limit that to 74.98, then you don't have to come to the Siting Act. So I think that is definitely a result, and that's how this would play out. And so I'm find myself agreeing with counsel for Pine Gate on that.
Thank you. No further questions at this time, Chair. Thank you.
Thank you, Commissioner. Mr. Cooper, let's follow up on that 200 megawatt hypothetical gas plant that gets built, but there's some sort of control there that's only going to put 75 megawatts on the grid. Okay. let's suppose Dominion's building that. Dominion's going to have to come in here and seek cost recovery for that plant, don't you think?
I would think so, Commissioner.
And would that be a prudent investment to build a gas plant capable of 200 megawatts that Dominion says we're only going to put 75 megawatts on the grid?
Well, Chair,
I know that's a different scenario, but there's a prudency determination that's going to have to go into that with the regulated utilities, correct?
I think that's a fair point. Where my skill set is limited is, and I think there will be the opportunity to ask other people questions like, I don't know. There are people who probably can tell you this, but maybe it depends on where gas prices are. Maybe it depends on what transportation prices are. And so those things may all influence and say, well, today we're going to limit this. I also know that sometimes when you purchase turbines, you purchase the gas turbines in blocks. So it may be more efficient to buy the next block, but limit the amount or the output, because that's how the turbines are sold. Again, I'm skating
I know,
to the point.
That's going on to the next level, but
I can
just
see
think,
Mr. Cass is starting to get really nervous over there.
I just think the hypothetical is a little bit misplaced, I think, when it comes to if it's a regulated utility and what they're going to put out there and they're going to seek recovery for, they're going to be judicious in that. And anybody, is it not fair that, okay, these are solar developers, but they are going to build something that they can make money off of, right?
That's right.
So are they going to be looking to, quote, overbuild something to the extent that it may cost their return? It's just a thought. You don't have to answer.
Well, I think I can. I mean, and look, nothing about this, I want to be very clear. We are not saying there's any bad intent, and there's nothing bad intent about optimizing for profit. But I mean, the reason why I showed the Broadview order is because they clearly saw that there were economies to overbuilding at 160 megawatts and building a 50 megawatt battery storage facility and limiting the output to 79 megawatts. So, I mean, that's right in front of us. We know that's been built and it was economical. We know that Pine Gate has built a facility at roughly 100 megawatts and limited the output. Catalina is going to be 97 megawatts. They're limiting the output to 74. So, I mean, I just go off of what's publicly available. This is not, I didn't do the calculations, but that's publicly available that does go towards your, and then just real quickly, if I may, on the gas was merely, please don't read into that too much. I don't know of anything. I don't know of any plans or sensitive plans. I guess what the reason for bringing that up is I understood a commissioner to ask a question about, could you overbuild a coal plant and then reduce the size? And so my reason for not repeating that question verbatim was that, and I'm testing my limits, but I understand that gas turbines are built in blocks. So a more realistic example is the next block
I understand
would
what you're
put
saying.
you over, and you might limit that.
And I don't want to get too far down that rabbit trail because we could spend the rest of the day debating that. But the point of the matter is there's got to be some sort of economic benefit to what's being built.
Yes.
And with a regulated utility to come in here and seek cost recovery, they would have to, there'd be a lot of questions about overbuilding to such an extent and then limiting the output, I would think. But that's a discussion for another day. I appreciate your putting up with me on that. Thank you. Commissioners?
Madam Chair, may I ask a follow-up?
Commissioner Caston?
That did generate, well, good question. Relative to, I guess, well, I don't want to get into the economics of it, but if the Siting Act is 75 megawatts something, and Dominion's argument is it would apply to the public utilities and the private investor. Is that correct?
That's correct, but applies equally.
So if the mandatory purchase I guess from the QF facility, if it's a QF facility, from FERC, it's 80 or less.
That's correct, Commissioner. And it must be renewable. You could be a QF and be a cogen, and there's a different standard. It could be unlimited in size, but it has to meet certain technical and engineering tests to be use and useful. But we're really getting outside the Siting Act, but just to clarify. But yes, Commissioner.
I think I'll just stop there and wait until we get to the technical folks. But thank you very much.
I appreciate it. Thank you, Commissioner.
Commissioners?
Madam Chair.
Commissioner Irvin?
Thank you. Mr. Cooper, good afternoon, sir.
Good afternoon, Commissioner.
Would you agree that when it comes to land use restrictions, that's really not a matter for the Public Service Commission of South Carolina, is it? It's a matter for the county zoning board, if they have a zoning ordinance, or a land use planning issue that would be heard at the local level. Would you agree with that?
Respectfully, Commissioner, as it relates to this proceeding, which is interpreting the purpose and the requirements, the legislative requirements of the Siting Act, I think the legislative requirements in the plain text of the Siting Act does not agree with that statement.
Well, let me ask you this. This particular plan is, I believe it's cited in Saluda County, is that right?
Yes, Commissioner, I believe that's correct.
Did the Saluda County Planning and Development Board seek to intervene in this proceeding?
Commissioner, I am not prepared to tell the commission what that county was thinking or their view on this is. But it is my argument that the Siting Act, as written by the General Assembly, does not allow you to show some other means of complying with the express requirements in written words of the Siting Act.
So are you contending that the Public Service Commission has an obligation to investigate every site to determine land use issues?
No. Well, Commissioner, I'm not sure I follow that question. What I am saying is that the legislature was very specific. And they said where you have a generating facility that's designed for or capable of operating at 75 megawatts, regardless of what it puts out, whether it's designed for or capable of, before you commence construction, you must come into this commission and you must seek a certificate of environmental compatibility. And this same act provides a mechanism for people who have an interest. It provides a mechanism for people, other state agencies like Park, Recreation, and Tourism that presumably have an interest in land use, Department of Natural Resources that presumably have an interest in land use and the environment, a DHEC that presumably has an interest in land use, the environment, and public health, as well as nonprofits that have an interest in environment, public health, historical sites, conservation. The legislature intended for the proceeding to be able to take all those things and provide a forum for a discussion on all those points.
And so did any of those entities that you just listed and named, did any of them intervene in this docket to express concerns about any of those requirements?
Well, the Office of Regulatory Staff is a party of record, and obviously they initiated getting a clarification.
Well, is that the same as taking a position on the issue that's before us?
Well, the issue before you is interpreting what the Siting Act says in terms of the 75 megawatt requirement. it certainly could be, Commissioner, and I don't know. I don't speak for Parks, Recreation, and Tourism. I don't speak for DNR, and I don't speak for DHEC. Perhaps if the issue was analyzing to what extent people had the right to look at the environmental impacts, if it was to look at land use, if it was to look at historic relics, perhaps they may have intervened. Perhaps they said, well, if this is about the technical application of design for and capable of, that's not as much of our interest, and I don't know why they didn't intervene, but based on the docket, I don't see any evidence of those parties attempting to intervene.
That's right. And certainly had they had those kinds of concerns that you just mentioned, like environmental impacts, that's primarily a Department of Health and Environmental Control matter, is it not? They would be the ones that would come up forward and say, Public Service Commission, take note, we've got these concerns about environmental impact. They'd be here today, right?
Well, respectfully, Commissioner, I believe that goes to what I was just saying. Those issues aren't being decided today by the Commission. What's being decided today by the Commission is a rather discrete issue, and that is, how do you determine what is designed for and capable of 75 megawatts? That's the issue. Those issues that you mentioned, the Commission is not weighing in on those issues today.
That's right. I just wanted some clarity on that. The other question I have, what is the status? What's the current status of these solar facilities? Are they up and running and operating, or are they in construction? It's not quite clear to me. Could you give us an update on what's happening on the ground?
With the Catalina plant, the Catalina plant is, I believe, that's maybe more appropriate for Pine Gate, but I know that what was filed in the briefs is that Dominion provided them an extension of time and held all their obligations in abeyance so that they could seek a clarification from this commission without in any way being prejudiced or jeopardize their plant from moving forward. So I would assume it's an active plant. It's somewhere in the development stage.
Okay. And the bottom line is that aren't you asking the Public Service Commission to simply ignore 50 plus years of precedent and applying the law that interprets the act, the Siting Act?
Respectfully, Commissioner, no. And as I mentioned, I began my statement, I believe both ORS and Pine Gate acknowledged in their petitions and in their briefs that this is a matter of first impression for this commission. The commission has not been on record. The commission's not bound. There's no, this is the first time the commission is really clarifying its jurisdiction. So respectfully, that is not the position of Dominion Energy.
The final question I have is, you mentioned the concern about having battery storage sited with the solar. And if we follow your logic, that would effectively prevent any solar facility, including Dominion's, from having battery storage available to store generation until it's needed under the limits. Wouldn't that be the practical effect?
Well, Commissioner, I have two answers for that. Again, respectfully, I don't have a concern. I didn't raise concern about battery storage. That's a matter that has nothing to do with my concerns. I don't think that's at play here, that Dominion has a concern about battery storage, and I do not. The fact of the matter is that battery storage, it was relevant to show that was a plant that's in existence that has a useful use for the DC power it's capable of generating, and it puts it into the storage facility. And Commissioner, respectfully, I don't think, given the, if you look at the IRPs that are out there, I don't think that, I think you're going to be able to show that there's a need and there's a public need for battery storage. I don't think battery storage is in jeopardy just because you have to apply for the Siting Act. I mean, keep in mind, you have to cite 400, 500, 600 megawatt generating plants. So citing a 50 megawatt storage facility, I don't think should cause anybody concern. This is just a matter of, are we going to follow what the legislature set forth in terms of the boxes they want to see checked and the I's dotted and T's crossed. I don't think it's about jeopardy or a prognosis on the future.
There's one other thing I meant to ask you about, and that is, has Dominion Energy, I assume these plants are in your service territory. Is that true?
That's my understanding, Commissioner.
Right. Has Dominion Energy South Carolina already entered into a power purchase agreement with Pine Gate?
Commissioner, respectfully, I prepared for a lot of things today, and I don't want to confuse my words. Is that something, I know there will be a chance to ask some technical witnesses, or I could follow back up with the commission, whatever the chair would like. I just don't know the answer off the top of my head, and I don't want to guess and be wrong.
Sure. We'll find out maybe perhaps from someone else, and if no one can tell us, maybe we could have a late filed exhibit to clarify that point.
Thank you, Commissioner. I appreciate that.
Thank you. Thank you, sir. No further questions.
Commissioners? Thank you, Mr. Cooper.
Thank you, Chairman.
Sasiba? Mr. Snowden?
Thank you, Chair Belzer. I might just take a moment to get my slides up in here. Thank you. Sorry, just a moment. I have to get a password for this hearing room device to get that open. So if you'll indulge me for a moment.
I don't know it. Joe, do you know it? Mr. Snowden, court reporter. Okay. Oh.
All right, thank you. I'll defer on putting these up for just a moment. Chair Belzer, Commissioners, Ben Snowden here for the for CCBA. I'd like to start. There's a lot to respond to. There's been a lot of great discussion so far. I'd like to start by responding to a few of the things that have come up so far. The first thing is Mr. Cooper sort of portrayed, how we got here as this question about DC versus AC sort of arising organically in the context of the Savion decision, where the commission sort of portrayed that as the commission having brought that question up. In fact, the projects at issue in Savion were interconnecting to Santee Cooper, sought a determination from this commission that they were not subject to the Siting Act. Dominion intervened in that docket and strongly opposed the request by the petitioners for a determination, and said that information about the DC rating of the facility was necessary for the commission to resolve that. So this is not a question which was sort of arose organically. It is one that Dominion has brought to the commission. Also, there has been this discussion that sort of the hypothetical, 200 megawatt gas plant or 500 megawatt coal plant that only outputs 75 megawatts to the grid. I think, Chair Belzer, I think you're absolutely right to sort of question whether that's a realistic hypothetical, given that a utility's got to go and get cost recovery for that. And if it's a merchant generator, it's got to sell that power. I also would respectfully disagree just a little bit with Pine Gate's counsel on what you need to look at in terms of assessing whether a facility like that is subject to the Siting Act. I think consistent with the language of the Siting Act, you have to look at whether that electric generating plant and associated facilities as a whole were designed for and capable of operation at a capacity of more than 75 megawatts. So you need to look at, what you need to do is just look at that facility as a whole and see what it is capable of generating. Now, Commissioner Jay Williams, I think a little while ago, was asking about the sort of design of solar facilities where the DC rating was substantially in excess of the AC rating. That's often called sort of the inverter loading ratio, and it's typically, and this is sort of across the industry nationwide, solar projects are usually built with these inverter loading ratios of about 1.2 to 1.3, so they'll usually be a DC rating that's about 30% higher than the AC rating. That's not, the purpose of that is not to game these sort of statutory thresholds. I mean, this is true nationwide in markets where there's, where PERP is not effective or is not sort of doesn't provide a threshold. It's my understanding, and I think these are good questions for Pine Gate's witnesses, is that that inverter loading ratio, we've got higher DC than AC capacity, higher DC rating than AC capacity, is that it makes the resource more reliable, right? You can get closer to your AC output during more hours of the day instead of just generating that at your AC level at 10% of the time or 5% of the time. You can be a more reliable resource and output at your or close to your AC rating more of the time, and that it just makes it a better resource for the system. That's something that I think is certainly in the context of other dockets here before this commission, the utilities have said it would be better if solar was less variable and more constant. And so that higher ILR helps accomplish that goal of system reliability. Commissioner Caston also asked about the fairly recent amendments to the Siting Act. I think the most recent one was around 2021. I think it's worth noting that, as of 2021, this commission had applied the Siting Act in a consistent way since it was passed, looking only at AC. At that time in 2021, there were solar facilities with filed PPAs that had DC ratings higher than 75 megawatts, but AC ratings less than 75 that hadn't gone through Siting Act approval. If the General Assembly had thought there was a problem with the way that this commission and the utilities and the industry had approached this issue of Siting Act applicability, when they opened the statute up in 2021, they could have told you this is how you should do it. They did not. They stuck with the status quo. They thought the status quo was fine. I think that is a fairly important, directive from the General Assembly that what you have been doing up to this point is acceptable and is consistent with the statute. Commissioner Williams, you had asked, very early on about, I think your first question was where, if at all, in the South Carolina Code direct current appears. As far as I can tell, it appears one time in the South Carolina Alarm System Business Act, where it describes electric fences with as having a DC rating or a DC being powered by DC battery of 12 volts or less, and that's the only place where it appears. Whereas AC rating, it appears in the South Carolina Energy Freedom Act, recently passed in 2019, where it describes capacity as being an AC. It applies, as Mr. Torini notes, many times in the interconnection procedures, in the PPAs and the form documents that Dominion and Duke have proposed and that this commission has approved. It appears AC capacity is defined by reference to AC rating in Dominion's own appendix to the interconnection procedures that they proposed for their cluster study. So it is, everywhere it is AC and nowhere is it DC. So I'd like to turn back. Mr. Torini discussed this at some length. I'm not going to dwell on it too long, but it's a fairly narrow question of statutory interpretation that you have before you. I know there's a lot of things in play here. And really the question is an electric generating plant and associated facilities designed for or capable of operation at a capacity of more than 75 megawatts if only a single component of that, that generating plant has a DC rating of more than 75 megawatts. Mr. Cooper has accused Mr. Torini of reading words into the statute that aren't there. I would submit that Mr. Cooper and Dominion's interpretation of the Siting Act reads out words that are there. The statute clearly says that you should be looking at the electric generating plant and associated facilities. That's the whole generating plant. It's not just a single component of the generating plant. Dominion, alone among the parties in this room, says that for solar facilities, you have to look not at the generating plant, but at the solar array all by itself. Now, a solar array is not a generating plant any more than an engine is a car, right? The engine, it makes the car go. The engine certainly affects how fast the car can go and how far it can travel, but there are a lot of other things that dictate how fast and how far that car will go. There's a transmission, there's suspension, there are tires, there are the aerodynamics of the car. And the purpose of these things is not to limit the power of the engine. They are just necessary parts of the vehicle. And so just in the same way, an inverter and the interconnection facilities are all necessary parts of a solar facility. They do not exist to limit the output. They have to be there. So the Siting Act says, look at the generating plant and associated facilities. Look at the car. And Dominion says, no. Just look at the engine. But an engine is not going to get you anywhere by itself. And notably, nobody looks at capacity in the way that Dominion suggests. Other parties have and I have discussed numerous examples of how capacity is referred to in AC throughout the industry, throughout in federal law and in state law. I think Broadview, which Mr. Cooper discussed at some length, is relevant for that. Not so much. I acknowledge that Broadview is not binding on this commission. It does apply to PURPA, but what the FERC order in particular helps us understand is, well, what does capacity mean in the context of the electric industry? When the General Assembly passed the Siting Act, what did capacity mean? Everybody understands it to mean AC. Dominion is the only party who says, do it in DC, and they have not cited a single instance under federal or state law where capacity is interpreted in that way. Now, the only reason that Dominion provides for ignoring the statutory requirement to consider the entire generating plant is that Dominion says this is necessary, this better accomplishes the goals of the Siting Act, which it says are environmental review. Now, and Dominion argues that the Siting Act is at its heart an environmental review act. We'll talk about that in a moment or two, but let's just assume that's the case. So assume that the Siting Act is an environmental review act. Is it the purpose of the Siting Act to subject every single generating facility to environmental review? No. The General Assembly said that only major utility facilities would go through Siting Act review. And they set this 75 megawatt threshold for deciding what is a major utility facility. So Dominion's claim, and this is very important, Dominion's claim is that when the General Assembly put that 75 megawatt capacity threshold in the law, it intended capacity to be a proxy for the environmental impact of the facility. Or they have to establish this because whatever the purposes of the Siting Act, their interpretation of capacity only makes sense if it's a proxy for environmental impact. Now, there are a couple of problems with that. One, there's just no textual support for it. It's something that they think is appropriate, but there is no support for that in the history of the legislation. The other problem is that capacity is a terrible proxy for environmental impact. You can take a 75 megawatt coal plant, and it's going to have very, very different environmental impacts than a 75 megawatt gas facility, 75 megawatt hydro facility, or a 75 megawatt solar facility. Wind and hydro at 75 megawatts take up, I believe that SCLC's brief has the details, but my recollection is it's somewhere like 3 to 5 times the amount of land per megawatt. An SMR is going to use less, right? So the notion that capacity is supposed to be this proxy for environmental impact, and that a major utility facility is one with a major environmental impact is just inconsistent with reality. Furthermore, as Mr. Torini mentioned, if the General Assembly had wanted to base the applicability of the Siting Act on environmental impact, it would have done that. It could have said acreage. It's done that in a lot of other statutes. It could have said, well, based on emissions. It could have said, use some other proxy or other indicator of environmental impact that made more sense. Capacity makes sense if you're thinking about, okay, well, how significant is this facility to the utility? How significant is it sort of in the overall context of providing service to customers? It does not make sense as an indicator of environmental impact. So even if the primary purpose of the Siting Act is to enhance environmental review of new generating plants, that does not support the use of DC rating instead of AC capacity. So the question then arises, is the Siting Act primarily an environmental statute? And there's a lot of discussion about this. Dominion certainly frames it as primarily an environmental statute. I would say certainly, Mr. Torini has acknowledged, I acknowledge environmental review is an important part of the Siting Act. But I would submit that the purpose of the Siting Act is not to enhance environmental review. It is to streamline environmental review for major utility facilities, in part to make those things easier to build. Mr. Torini sort of went through the fact that this commission, before issuing a CPCN, has got to look at other factors besides environmental impact and has to balance environmental impact against those factors. So I won't go over that again. But I do think you have to ask, when thinking about the purpose of the Siting Act, what does it mean for environmental review if the Siting Act does apply? Would expanding the scope of the Siting Act to cover more facilities lead to more or to better environmental review or land use review? And the answer is no, for a few reasons. First off, and this is discussed more in testimony, but solar projects already have to undergo extensive environmental review, even whether or not the Siting Act applies. Solar projects, they don't have to get air permits because they don't generate air pollution. They don't have to. They don't generate waste. They don't make any noise. You could live 100 yards from one for 35 years and you would never know it. But they do have to comply with the environmental statutes and regulations that address their potential impacts. They have to comply with the Clean Water Act. They have to comply with the state's Stormwater Management and Sediment Reduction Act. Every solar site, every construction site that is over an acre has to get a stormwater permit and has to submit a stormwater pollution prevention plan to DHEC for approval. So DHEC is involved in every single solar facility. The Endangered Species Act is triggered if there is a possibility that there will be species impacts, so there'll be consultation with the Fish and Wildlife Service. There are FAA requirements that apply, whether or not the Siting Act applies. Importantly, and Commissioner Irvin talked about this a bit, solar facilities have to comply with local requirements. Every utility scale solar project in South Carolina negotiates a fee in lieu of tax agreement. It's not a regulatory requirement. It is a business necessity. It's discussed in testimony. By law, those fee in lieu agreements have to be approved by a resolution of the county council of the county where the solar facility is being built. That entails public notice, public hearing for every single project. In addition, solar projects have to comply with local zoning requirements. South Carolina law gives local governments the right to decide whether to allow development of solar facilities in that jurisdiction, and it allows them to set additional conditions like setbacks and buffers. This is land use review that happens even when the Siting Act is not triggered. I would also note that even where the Siting Act is not triggered, those other issues that come up under the Siting Act include reliability and need. This commission regulates the interconnection procedures. Those procedures are designed to ensure reliable interconnection of projects. So this commission has the ability to regulate reliability impacts. This commission also has, through its IRP proceedings, through PURPA proceedings where those are in play, and through its supervision of any competitive procurement programs, this commission has the ability to regulate solar sites with respect to the issues of need and what have you that also come up under the Siting Act. So again, so when the Siting Act is triggered, it doesn't add any environmental requirements. The commission does have to conclude that the facility will comply with other laws, with a big asterisk here. But it does, in fact, in some respects, actually if streamline, or perhaps some would say undermine, undermine is probably not the right word, it certainly limits the environmental review that a solar facility or any generating facility is subject to. So here are a couple of statutory citations. If you look at the Sedimentation Act, a utility-built facility that gets a CECPCN is not subject to the Sedimentation Act, doesn't have to get a permit. A hydroelectric facility that gets a CECPCN doesn't have to go through DHEC permitting. Every other, I won't say every other, most other hydro facilities that are not sort of solely built on private land have to get a DHEC permit that requires DHEC to look at sort of a broader set of environmental considerations than would necessarily be coming up in the Siting Act. The Siting Act also says, and this is extremely important, no state or regional agency, municipality, or government can require any permit, any certificate, or any other condition other than what's in the CECPCN. So a state agency or local government, if the Siting Act is triggered, cannot impose any requirement that's not in the CECPCN. They have to come to you and ask you to impose it. So it turns those agencies from the deciders, the people with authority, to petitioners, to parties that will come in and they will of course try to persuade you, and you will do your job in ensuring that the law is required with. But that's certainly a very different arrangement from when those agencies and those local governments are the ones who have the power to decide what conditions are going to apply to solar facilities that are built where they live. In addition, as Mr. Tarani noted, and this is the asterisk, the commission can refuse to apply any local law or local regulation if it finds that that such law or regulation is unreasonably restrictive. And this is important too, in view of the technology, the factors of cost or economics, or the needs of consumers, whether located inside or outside of the directly affected government subdivisions. So this means that where the Siting Act applies, again, the commission steps into the shoes of the state and local authorities, but it can override local requirements if the commission thinks it's too restrictive or justified by the needs of the utility's other customers. And this is not to suggest that this commission will not respect the prerogatives of local governments, but it is to say that the intent of the Siting Act was not to enhance or expand environmental review. It was to streamline it for a certain set of facilities that were of significance to the system. This is also fairly important. Mr. Cooper discussed at some length the parties that were sort of automatically made, the entities that were automatically made parties to a Siting Act proceeding. And this is important. The Siting Act, in the very last section, says, no court of this state shall have jurisdiction to hear or determine any issue, case, or controversy that could have been brought up in a Siting Act proceeding, right? And there's some language that's not here. I'm sorry, I omitted it from the end there. This only applies to entities or persons that are party to a Siting Act proceeding. But those local governments are automatically made parties to a Siting Act proceeding. So they must, if they want to have a say, they must come to you and participate in the Siting Act proceeding. Speak now or forever hold your peace. And that is the approach of the Siting Act. So again, the intent of the Siting Act was not to enhance environmental review. It was to streamline it, expedite it, centralize it with this commission, take it out of the hands of local governments and state agencies so they can't block the construction of a generating facility. Now, the General Assembly decided that was appropriate for major utility facilities. They have said that that's appropriate. That is the right approach for major utility facilities because they're significant to the system. But expanding the scope of what is a major utility facility is not going to result in greater or enhanced environmental review of solar facilities. What it will do is reduce the ability of local governments and local people to exercise control over development that is occurring where they live. Now, Commissioner Williams, Sir Jay Williams, I think asked a very important question of Mr. Cooper. What is at stake here, right? What would the impacts of expanding the Siting Act, the reach of the Siting Act, to cover a lot of solar facilities more than it already does? What would those implications be? Now, if you're a utility, and this may be the question, this is a question I would ask me, if the Siting Act streamlines environmental review, right, if it makes it easier to build facilities, why do we care about that? Why aren't we saying, yes, this should absolutely apply? If you're a utility, having the Siting Act is helpful because it does centralize that review. It does give you the opportunity to sort of say, well, our other customers need this facility. It's got to go here. Local guys, I'm sorry. If the utility doesn't get that CPC in, right, this is a Siting Act, it can site its facility somewhere else, right? It cannot build it. It can go somewhere else. It can do something else. But it's really important to note, utilities are not on the same kind of timelines that independent power producers are. Independent power producers don't have they get site control. They don't have the ability to say, well, I'm just going to build this, facility somewhere else. The Siting Act does not, as a practical matter, although we all have the same burdens under the Siting Act nominally, it doesn't result in equal burdens among all players. So if you bear with me for a minute, I'll try to explain why Siting Act applicability is very problematic for an independent power producer. So as you would imagine, there is a fair amount of uncertainty in the CECPCN process. There have been very few that have been granted for solar facilities. One thing you do know is it'll take a while, but you don't know exactly how long. And you honestly, ultimately you don't know whether you're going to get one, right? Because it's up to the commission to decide whether you do get one. It's never been done in less than 6 months. I don't see any reason that would change. The problem is that and Mr. Cooper said, well, you should just go ahead and get your CECPC and everybody can do that. It's fine. The problem is that the way that the interconnection procedures and the procurement procedures are set up in South Carolina, independent power producers have to make major financial commitments that in the development process, that they have to forfeit if they withdraw from the process. Which you would have to do if you didn't get a CECPC in.
Mr. Snowden.
Yes, ma'am.
I'm sorry to interrupt, but how does the impact on the independent power producers, how does that address this AC/DC issue that we are really here to decide?
Chair Belzer, it does not. I'm simply trying to respond to Commissioner Williams' question. I'm happy to move on if you'd rather not hear on that.
I don't really think that it's relevant to the proceeding, if you don't mind.
Okay, I'll move on then. Thank you. Okay. Well, those are all the points that I had to make. I'm happy to answer questions if I can.
I'd have a couple of brief questions, and if we're going to get too much further, we'll
I will
see how
try
far
to
we can
give
go.
brief answers.
I understood you to say that the local governments and municipalities are parties to a siting.
I believe that they are automatically made parties if they receive notice.
They have to.
I'm sorry. It is the agencies. I apologize.
They have to petition to intervene.
Yes. I'm sorry.
But they have to receive notice of the application. They have to receive the application. But
yes,
then
ma'am.
they have like 30 days, I think.
Yes, ma'am. I'm sorry. Chair Belzer, you were correct. I was confused. It is the state agencies that are automatically made parties, not the local governments. I'm sorry.
Thank you. And you made a comment that it's never been done in less than 6 months. Were you talking about I think you were at that point maybe talking about the building. You weren't talking about the siting, a siting proceeding taking 6 months, were you?
To my knowledge, facility determinations have certainly been done in less time than that. My understanding, we've looked at this, is that a full siting act proceeding in recent memory has not been done in less than 6 months.
Okay.
If I am wrong about that,
But you're aware that a hearing has to be scheduled within no earlier than 60 days after the filing of the application and no later than 90 days.
yes, ma'am. I
Okay.
understand that the hearing has to
So
be.
that's looking at 3 months, and
Mhm.
it could take 3 months to get a decision and order out, but hopefully we can improve on that. So.
That would be wonderful. Yeah, I'm
Okay.
just looked at past timelines is all.
Okay, thank you. Commissioners, Commissioner Caston?
Good afternoon.
Good afternoon.
So, did I understand you to say, and sometimes I don't know if I hear it clearly, you said a solar array is not a generation plant? Did you say that, or what did you mean again?
That's correct. Commissioner Caston, an array of solar modules all by itself is not a generating plant. An array of solar, it's like the engine of a car, right? It's the thing that makes the thing go. You have to hook it up to an inverter or inverters. There are interconnection facilities and other equipment that, as a lawyer, I don't fully understand, but that are required to actually operate. Under Dominion's view, you just look at the solar panels, and a warehouse full of solar panels would be a facility if the total DC rating of those panels was over 75 megawatts. They don't care about how they actually operate.
Well, this may be, if this is getting into the technical, stop me and we'll wait on them. But in the act, where it describes major facility, it does say electric generating plant and associated facilities.
Yes, sir.
In a solar facility, a generation plant and associated facilities, what component, what part, what associated facility? Let me back up.
I think I understand your question.
What,
Sure, go ahead.
What generates the electricity?
The whole, it's a question about what generates. The electrons come out of the solar modules.
Does the inverter generate electricity?
The inverter does not generate. The inverter changes DC electricity into AC electricity and also provides other grid support services.
Does the solar array generate electricity?
The solar array, it does if it is hooked up to an inverter.
You're saying it can't generate electricity if it's not, if it doesn't have an inverter on it. Is that what you're saying?
That's correct. It needs to pass through the inverter to be usable. There is not a solar facility, to my knowledge, that generates power for the grid that does not have an inverter. It is an inverter-based resource because it generates power in DC, and that's not usable on the grid.
And this may be the technical part, and stop me if it is. Can a solar array not just generate DC power for battery charging?
It does generate power for battery charging. The batteries themselves have inverters. I don't know whether the inverters are located whether you can hook up solar panels directly to a battery or whether there's got to be something in between there. That I don't know.
When in every plant, do you agree that there are associated facilities, which may be transformers, power lines?
That is my understanding, yes, sir. Yeah, and I believe it's Duke's brief that sort of sketches out their view of what the associated facilities are. It's not a I've looked. I don't know that associated facilities has ever been defined under the Siting Act. It's sort of an open-ended term, but I think my understanding is that it would refer to the interconnection facilities, a substation, those sort of things that are required to interconnect to the grid.
Also, I thought I heard you say that you use hydroelectric facilities.
Yes, sir.
Hydroelectric facilities don't have to go through DHEC or something. And then it was was that what I heard you say, that a hydro facility doesn't have to go through all the same things like DHEC that
Yes, sir. There is an exemption. So there's the general DHEC permitting scheme for hydroelectric facilities. It's got some exemptions built into it. One of the exemptions that is in that statute says if and that DHEC permitting, you probably know more about this than I do, requires DHEC to look at what's the historic use of the stream. It requires DHEC to conclude there will be no impact on, I don't know if it's aquatic species or something like that. It's a fairly stringent standard. They have to conclude that the use of the hydroelectric facility greatly outweighs, or the need greatly outweighs, the historic use of the waterway. If a hydroelectric facility gets a CECPCN, they are statutorily exempted from that requirement.
Okay. If it's a FERC facility or a mill facility for just on-site use, that's a different category, correct?
I believe so, and I think there's also an exemption for FERC licensed facilities as well. I believe that's another statutory exemption. That they don't have to get a permit from DHEC because FERC's got its own. Again, you probably know more about this than I do. FERC has its own permitting regime.
I won't go there. We don't need to go there anymore. I'll follow up with that on the other stuff. But relative to the studies, if I understood you correctly, saying the Siting Act. Well, I don't want to put words in your mouth. If a facility falls under the Siting Act, are you saying that does it create another study, or it does not require as much study? That wasn't clear to me.
Okay, yeah, I'm sorry if I wasn't clear. The Siting Act does not require any additional studies. If you look at the application requirements, what the developer or the utility has got to file in the application is existing studies of the environmental impact of the facility. Now, the commission could conceivably require additional studies, but the act itself doesn't require any additional studies, and it doesn't set any specific thresholds or specific, environmental requirements. Ultimately, the commission has to conclude that any environmental impact is justified by the need for the facility and is consistent with the public convenience and necessity, which again sort of goes to the notion that this is a statute that is all about utility resource planning, and that this sort of special centralized review is appropriate for facilities that are of major significance to the system.
So the act is basically what it says here, just ask for a summary of any studies and notify all the agencies and everyone that may have an interest.
Yes, sir. And the commission has got to conclude that the facility will comply with all applicable legal requirements, with that asterisk that it can override local requirements. So the commission does have to. I mean, it does. Other than the exemptions that I've said here, and the ability to sort of override local rules, a facility does have to comply with those environmental requirements. It's just that rather than having to go to DHEC and negotiate, okay, well, this is what our stormwater permit's going to look like. These are the conditions that we've got to undergo, or have that back and forth with local zoning authorities over what the conditions of your special use permit are going to be. Those parties have got to come to the commission and persuade you all, and you all have to analyze and conclude that these are the right set of conditions for this facility.
And finally, another aspect of the Siting Act is if it falls under the Siting Act, one of the things is it has to justify its need. Does it?
Yes, sir.
Does it need to occur?
Mm-hmm.
So that question being asked and looked into, would that not be in the best interest of the consumer and public to know that if it falls into that category?
Absolutely. I'll say this, and Chair Belzer, I'm going to have to get into the practicalities here. You're right. That is what the Siting Act does require. There are other proceedings. There are IRP proceedings. There are and will be competitive procurement proceedings where this commission is going to determine need for solar facilities. The utilities have all, either been required to or said they're going to do these competitive procurements. The problem that arises out of, or a problem that arises out of applying the Siting Act more broadly is that these procurement programs, for example, they require really big financial commitments. If you bid in, you got to put up security, and if you get awarded like a PPA. If you don't sign your PPA, you gotta forfeit $1 million or something like that, right? Because the procurements don't want speculative projects. They want real commitments in these procurements, right? And if you sign a PPA, there's liquidated damages. So what happens, or what may happen, is that in order to avoid the uncertainty of having a CPCN, you're going to have potentially have projects apply for CPCNs before they go into interconnection, before they go into the procurement processes, right? Because these bidders are going to need to get that CPCN process underway, so they can have a CPCN by the time they are putting up their money at the later in the process. But then you guys have got to decide, is there a need for this facility before you know whether it's going to get awarded, a PPA in the competitive procurement process. So it's sort of a catch-22. I know this. I'm sorry if it's sort of complicated dynamics, but the fact that you have to go through this, fairly extensive process of getting a CPCN makes it really hard to participate in a procurement, and that in turn makes it hard for you guys to decide, what projects are needed.
And you mentioned IRP and other studies, but the IRP is a planning document, correct?
Yes, sir.
Not a siting or design.
No, that is correct. I referenced the IRP because the IRP will set out the utilities. That's their resource plan. They'll say, we got to put a gas plant on in 2028. We got to do this, that, and the other. We intend to procure, or we need to meet our system needs, procure a few hundred megawatts of solar in 2025 or 2026. And that IRP, as I understand it, those decisions drive these procurement processes. So you are looking in the IRPs not at the need for a specific facility. If you think about solar, you're looking at the need for certain quantities of solar that are going to be procured, generally procured competitively.
Okay, final, I think this will be a question. What I understood Dominion's argument being on the site, the generating facility, regardless, AC, DC, it doesn't matter, it's agnostic. It's whatever it is, would trigger the Siting Act. And if, let's say, if that were to be the case, and the facility capability, capacity designed for is greater than 75, well, I guess as far as the Siting Act goes, that's less than 80, so it'd still be a QF. But if it was greater than 80, would the utility have to purchase the electricity from the facility?
If you're asking whether the utility's got to purchase power from a facility that's over 80 megawatts AC, no, they don't have to. If it's over 80 megawatts DC but under 80 megawatts AC, then assuming that this was a QF facility and it had met all the requirements, then yes, that mandatory purchase obligation would exist.
But if it were determined that it was agnostic as to whether it's AC or DC, and the facility, the generating facility, exceeded 80, what effect would that have?
If it exported more than 80 megawatts to the system at a time? Well,
not what's put into the grid, but if the Siting Act means, if designed for, capable of producing means, what it can generate at any point in time under ideal conditions, whatever that is. If that exceeded 75, if that exceeded 80, say 85, would that require the utility, the public utility, to purchase electricity from that facility, even if they had it reduced or in an inverter that put it into the grid at 74.97?
If you're asking what, if you're thinking about what the facility can generate, I mean, I'll submit that the facility is the panels and the inverters and everything together. That's going to be what comes out of the inverters. You know, probably minus the losses between the inverters and the. Well, more or less, what comes out of the inverters, what goes to the point of interconnection, that has got to be below. If that goes over 80 megawatts, then the mandatory purchase obligation. They I guess would lose their QS certification, but that's only that's like the last of a bunch of consequences that would flow. If you're asking what would happen if a facility sort of jacked up its output. So here's what I think would happen if a facility jacked up its output over what was, well, first it would have to get the inverter manufacturer to change the settings, and there may be other electrical reconfigurations. They'd be in violation of their power purchase agreement. They'd be in violation of their interconnection agreement. They would lose their QF status, or they could lose their QF status if someone, assuming the utility would probably challenge that. So they'd lose their interconnection. They'd have to go back through the interconnection process from the very beginning. They lose their PPA. The PPAs generally, if you default on your PPA, you're locked out of getting another PPA under a lot of the sort of under purpose, certainly for however long the term of the contract is. A lot of really negative consequences. Bad stuff would happen. Really bad stuff would happen. Probably the financing party would foreclose on the project. I mean, it's just Armageddon for a project if they exceed the limitations in their PPA and their IA.
Then do you agree that the Siting Act doesn't really care about whether it's a QF or not, or whether it's...
I don't think it cares. And I guess if the question is, maybe what you're getting at too is, if you had a project that was constructed, it was 75 megawatts or less AC. It didn't go through Siting Act approval. It got built, and then its AC rating went up. What would happen in terms of the Siting Act? I think this commission would certainly be well within its power to issue a show cause order and either tell the facility to stop operating or go back through the Siting Act process. Certainly, they'd be out of compliance with the Siting Act, I think, if that happened. What the remedies are is a good question.
Okay, that's enough. Thank you.
Okay, thank you.
Commissioner Williams, do you have a quick question, or do we need to hold till after lunch?
No, I think we can get to it now, Madam Chair.
Thank you.
Thank you for giving that background in terms of what's at stake. The reason I asked that question is it helps me understand you all's argument, because how you see the problem, in my opinion, determines how you interpret the law. To that end, I'm interested to know your opinion on why there's a limitation on how much or the amount of megawatts you say that can be put onto the grid. Others have a different way of stating that issue. Why 75 megawatts? Why any limitation at all?
Now, Commissioner Williams, are you saying a 75 megawatt limitation under the Siting Act or under
The Siting Act.
I think, and this is SCLC's brief has a really helpful discussion about sort of the context, what was going on nationwide at the time the Siting Act was passed. I don't think of it so much as a limitation on what you can put on, but it's how big a facility are we talking? What's sort of the size facility that the commission should get in, where the commission should step in and handle siting and environmental review and things like that. It's really more, how significant is this project to the system? It's not so much a limitation, and really, I mean, with facilities, any facility, you build it at a certain capacity. It's not as though, a solar facility or a gas plant. We have these hypotheticals about changing facilities to increase output. It's not really an operating limitation because you design your facility to a certain AC limit. And to go above that AC limit, you have to change your facility. So it's not like you're sort of constantly trying to stay under 75. To go over that limit, you would have to affirmatively say, okay, I'm going to change everything and jack up my output.
Understood. And maybe a fat witness will be able to answer this question. Maybe you can answer it. But you alluded to the DC-AC ratio and overbuilding the solar array to hopefully get greater output through the inverter to put AC on the grid. Now, again, I'm not an expert in this, but it seems to me that the larger the array, it increases the likelihood that you would get that nameplate capacity more often throughout the day. Is that a fair assumption?
Yes, sir. That's exactly right.
Okay. And I guess if that's true, then what's also true is that you're not getting that nameplate capacity throughout the day.
No, sir. I mean, if you think about it, and this is just a regular sunny day, the sun comes, solar's not generating anything at night. Sun comes up, solar starts generating, right? It ramps up, and then maybe at the hottest or the brightest point of the day, you might hit that 100% output and then sort of go back down. So you're only getting close to your AC limit or your AC output, your nominal output at that peak. If you have a higher DC rating, and you can do that by installing, not just by adding panels, you can do it by installing more expensive panels that are more efficient. Rather than just touching that AC output at one point of the day, you might be able to do it for an hour or two, right? So you've got a sort of constant output during that time, and you also ramp up faster in the morning, and you're putting more consistent, more constant power on the grid. If you think about a gas plant, right? The Holy Grail is like you want consistent output, right? You don't want a gas plant going up and down. They do a lot of things to try to make sure. I mean, for any generating facility, you try to make that output as consistent as you can, because that's what planners want. That they don't want big variability. It causes, you guys have heard in a bunch of dockets that having variability is hard for system planners. The utilities have said it requires them to have more resources, more reserves available on the system. So less variability means more reliability, lower cost, sort of overall. It's higher cost for the facility to build it, but it's lower cost to the system in general.
So here's where I get a little bit concerned about that. If all things equal, and I had as much capital as I needed to try to maximize my potential profit, I could build as large of a solar array as I could afford to, say, reach that nameplate capacity 80% of the time. How large would that be? I mean, we don't know, but under your interpretation of the statute, it wouldn't matter how large the array would be, and it wouldn't matter if I maybe even included some battery capacity, as long as I limited my output to 75 megawatts, I would be within the statute.
I think you have to look at how the battery issue is sort of you have to look at how the whole thing is operating. It's a tougher question, but I mean, I'll say yes. But if you look at, I think that 1.2 and 1.3 inverter loading ratio that we're seeing, and again, this is a better question for fact witnesses, but that ILR sort of you're seeing across the industry is a pretty good indicator of where it's economical to be, that's the ratio that is sort of most economical, because when you, building more panels is expensive, right? Whether it's more panels or getting, bifacial instead of monofacial panels that are more efficient, right? That's more expensive. And at a certain point, it's just not economical to have, a super, super high DC rating. And so I think that 1.2, 1.3 is sort of what's economical, because you can't sell anything over your AC output, right? That limits what you can sell.
I agree with you. I just want to clarify and make sure that you agree with me that your interpretation of the statute eliminates the commission from making a determination about the size of the solar array, as long as the output onto the grid is 75 megawatts and below.
Commissioner Williams, I wouldn't frame it as eliminating the commission from that. I would say that to what Commissioner Caston, I think, said a little while ago, that is the size of the facility is first and foremost a land use concern. That is, except where the Siting Act comes in and centralizes review, that is a land use concern that is best addressed, for anything besides a major utility facility, that's best addressed by local zoning authorities who have the power to do that.
Right. I don't disagree, but I want to ask it one last time. I'm just asking you to agree that under your interpretation of the statute, the local authorities and so forth and so on will be responsible for handling that part of the case, if you will, and really the commission role would be ministerial in that you all file these applications as long as it's under 75 megawatts, we just pass them through. Right? Maybe you don't like
I wouldn't characterize
words, but I mean, essentially, that's what would happen.
Well, I don't know that pass through is the best indication of what happens at the local level. I mean, these are very and I don't.
I'm not talking about local level.
Okay.
Commission. The commission.
Yes.
Once you file that application, it's below 75 megawatts. Based on your interpretation, there's nothing else left for us to consider.
I think the Siting Act is not triggered if the output, if the whole facility, regardless of a DC rating, if the whole facility as a whole, if the generating plant and associated facilities can't generate more than 75 megawatts, I don't think the Siting Act is triggered.
All right. Thank you, sir.
Thank you.
Thank you, Madam Chair.
Thank you, Commissioner. We're breaking for lunch. It is 1:33. Let's return at 2:50. That gives you about an hour and 15 minutes.